court has fixed this court itself has taken the matters to be mentioned and shifted on 13th of February at 12 noon. Correct.
My lord, my witness is on his way, my lord. He's somewhere. 5 minutes pass over I'm waiting for.
Oh, it can be kept next week.
Pass.
My lord, Mr. Haradhan Banerjee was arguing for the defendants. He is on his way, my lord. I'm seeking for a passover, my lord.
Okay, pass.
Most likely.
Only Madan Kumar Goswami. Madan Gopal Goswami, not versus. Where it has come? Ranjit Kumar Basu, advocate. The matter is listed as to be mentioned for correction of the order dated 25th January 2024. Full stop. In the cause title, inadvertently it is recorded as in the goods of Madan Gopal Goswami within bracket deceased DEC versus Ranjit Kumar Basu. But there is no versus full stop. In view of the this court find that there is no opposite party, namely Ranjit Kumar Basu. Accordingly, the cause title of the order dated 25th January 2024 shall be read as in the goods of Madan Gopal Goswami deceased only. That is come. Who typed?
May it please your lordship. My lord will recall this was an application for the discharge of the receiver, in a partition suit for gross misconduct and not complying with the orders.
Correct.
The last order was that we should file an exception. He's filed the audit report. We have actually we have filed the exception. I'll handle the exception.
Have you filed the exception?
Yes.
Defendant number 14. You are appearing for?
I am for
Defendant number 14.
defendant number 8.
Defendant number 8. Yes. Defendant number 14 pays for file exception to the audit report.
Yes.
Counsel for the petitioner, he has filed the application praying for grant of injunction after serving the copy. Who is for the other side? Nobody is there. You are appearing.
My lord, I'm appearing for the respondents, my lord.
Which respondent? There are so many.
Yes, my lord.
You are appearing for the 5, 6,
7, 9,
10A, 10B.
10, 10.
What is your instruction?
Have been instructed that we are interested in sale of the property.
And who is for the plaintiff? Mr. Arindam Paul. He has filed an application GA 9 for injunction.
Yes, he has filed an application for injunction.
Defendant number 14, where is the exception he has filed? Defendant number 14, who is appearing? Chandrachur Biswas. Nobody is there. Let it be passed over. I think all the things is of the view that the matter will be taken.
Yes.
I am
That will
passing
be
it over.
also the original exception is missing in my file. So let me just trace it out where it is.
I am passing it over. Paso. No, let the paso matter be clear.
Or I appear for the defendant.
Your Lordship, I appear for the plaintiff, Your Lordship.
Witness came. Witness is
Your
present.
Lordship. Yes, Your Lordship.
What to looking at?
Your Lordship.
कौन डॉक्यूमेंट जो प्रमाण करते हैं আমাদের সিকোয়েন্সটা এইভাবেই ছিল তো 5 মে আই মিলাট
Yes.
কিসের নাম Mr. Aich,
No disturbance.
I'm drawing your
Thank you.
attention to a document appearing at page 6 of the judge's brief of documents being serial number 5. Can we have a look at this document and tell my lord what this document is?
He's the first witness. Start
Yes.
or resume.
No, he's the first witness who has resumed.
Resume.
স্যার এটা একটা ইমেল মিস্টার কিশোর আগরওয়াল পাঠিয়েছিলেন আমাদের মিস্টার সৈকত ঘোষকে টু সৈকত ঘোষ
How is Mr. Kishore Agarwal connected with this, with the parties?
কিশোর আগরওয়াল is one of the director of রেলপাল
By objection. By Railpal, you mean the defendant. And Mr. Shoikot Ghosh?
he was looking after logistics department at that time in our company.
Okay. Now, in this mail, you will find that the plaintiff, that the defendant has forwarded certain documents in the form of attachments.
Yes.
Are you in a position to say as to which attachments form part of this mail?
3 ledgers of Railpal Logistics Private Limited. Page number 7, 8 and 9.
No, I think your lordship has Hey, তুমি বলো। Sorry.
Ledger Railpal Logistics Private Limited for the financial year 8-9, 9-10 and 10-11.
Okay.
7, 8 and 9.
Who used to maintain this ledger?
This was this is the ledger of Emas Mining and our company in the books of Railpal. Emas Mining and ledger of Emas Mining in the books of Railpal.
But this document we have denied and are objecting it to be marked as an exhibit.
Affidavit, you are denied.
I have denied it.
Give the affidavit document.
We don't. We don't want to do it.
Affidavit of 1st of August 23.
Dated. What is the
1st
document?
of August. This is the item number 4, which we have denied. See, the existence and the content both we have denied.
See, yes.
That is what I'm trying to prove, Miller. I know it's denied. That's the reason why I put it. Otherwise, why will I put questions on admitted documents? Sorry. Bol.
In the books of Railpal for the
Right.
financial year 8, 9, 9, 10 and 10, 11.
Now, can you tell my lord as to for which years, for how many years, and for which years did the plaintiff do business with the defendant?
For 2 years, 8, 9 and 9, 10.
8, 9, and 9, 10. Okay. Now, whatever transactions that you have done for the periods 8, 9, financial year 8, 9, and 9, 10 with the defendant, are they truly and properly reflected in pages 7 and 8 of the judge's brief of documents?
Yes.
Again,
ठीक है.
have these accounts? No, get it. At the end of the year, financial year 2009, 2010, what does the accounts show?
It is showing that 1 crore 20 lakhs 99,274 payable by Railpal to Emas Mining.
Don't say Railpal because Railpal is not a well-known figure. So either say plaintiff or defendant. Railpal बोले बुझबे की.
Payable by defendant to the plaintiff.
And what does the ledger account for the year ending 1st April 20 for the year ending 31st March 2011 show?
Same amount. Outstanding. Same outstanding amount.
By outstanding, what do you mean?
Payable by defendant to the plaintiff.
Payable by defendant. Now, witness, is it the first time that you have come across this accounts in this proceeding? Accounts? এই অ্যাকাউন্টটা কি আপনি প্রথম সরি বলেন বলেন বলেন
না না আগেও দেখেছি.
Now, according to the defendant, this accounts have the defendants are not sorry the defendants are not admitting the veracity and contents of these accounts. What do you say to that?
So করছে না. They are denying too.
Denying. আচ্ছা আপনার কি বলার আছে?
আমার কিছু বলার নেই, কেন ডিনাই করছে আমি তো জানি না, কিন্তু এটা ফ্যাক্ট।
I do not know why they are denying, but
Okay. Now, kindly come to no, kindly come to Paras. Before filing the suit, the present suit, did the plaintiff seek for refund of this 1 crore 20 lakhs, 1 crore 20 lakhs 99,274 from the defendant?
Yes, yes. We have sent 2 letters to them.
Can you identify the letters from the records of these proceedings?
One is page number 14. Refund of amount lying as advance towards rate premium.
Who also we have denied the existence. This letter also we have denied the existence and the contents. Well, item number 5 of our affidavit.
I know I'm only going only
That is
through
the
the denied documents.
That
I'm
is
not
only
going
pointing
through the
out
admitted
going as
documents.
an objection.
okay.
And page number 15. 14
I
and
have
15.
not yet tendered it.
50. And another is page number 15.
And another letter is page number 15.
Kindly tell, my lord, as to who has written this letter as page number 14 and to whom?
Written by Mr. R. Chattopadhyay, GM Finance of Mr. Ranjit Chattopadhyay, GM Finance and Accounts
Finance and account.
of plaintiff.
To whom?
To defendant.
To defendant. And what are the contents of this letter?
Refund of that advance amount. Contents of that letter.
And what are what is the contents of the letter of 30th April 2012 at page 15 of the judge's brief?
Same refund of that advance amount. Written by in page number 15, the letter was written by Mr. Kunal Chatterjee, Vice President, plaintiff,
Vice President of the plaintiff.
to defendant.
Now, after you had given these letters, did the defendant make payment in terms of this notice? What happened thereafter?
We have filed and we have আমরা একটা ওই লেটার দিয়েছিলাম খৈতান এন্ড কোম্পানি দিয়ে ডিফেন্ডেন্টকে।
We had sent the defendant a letter to our solicitor,
And company. Are you referring to the letter at page 17 of the judge's brief of documents?
Yes.
Are the contents of this letter true and correct?
Yes.
Milord, may I start by এটা তো already marked হয়ে গেছে কি?
Yes.
It's already marked. C.
It is marked.
It's already marked. C is marked. It's a common document. Now, in this document, in this notice, you have again demanded the sum of rupees 1 crore 20 lakh 99,275. Did the defendant pay any part or portion thereof in terms of this notice?
No.
No. What happened thereafter? What did the plaintiff do?
We have, we have filed this. We have filed a suit.
Are you referring to this suit or any suit previous thereto?
No, this suit. No, previous suit.
I am referring the previous suit which filed by the plaintiff.
I am drawing your attention to page 28. এটা কত? এটা কমন ডকুমেন্ট। আমার ভিতর Are you referring to কে ছিল প্রশ্নটা? To page number 19 19 to 48 of the judge's brief of documents. Is this the suit you are referring to? Is this the proceedings you are referring to? Suit.
Yes.
For the record, can you read out lightly page 21 being the notice of petition?
21. To Railpal Logistics Private Limited, 86-B/2 Topsia Road, flat number.
No. What is the nature of the petition? I want to know what is the nature of the petition. You are saying it's a suit. What is the nature of the petition?
Take notice that a petition under section 43,
43.
433, 434, and 439 of the Companies Act 1956 for your winding up, presented by Bipasha Banerjee.
That's it. Good enough. So would I be correct in saying that for recovery of the sum of rupees 1 crore 20, the plaintiff had filed a winding up petition, not a suit?
Winding up.
And that winding up petition is appearing at pages 19 to 28 of the judge's brief of documents.
Yes.
19 to
Milord, it is although their disclosure, Milord, it can go and as a common document because I am also relying on it.
they are relying upon.
But I don't know whether they will prove it or not.
It's a common document. It's a court
It's not a
proceeding.
common document. It's not even marked as a common document. That's the reason why. Only 3 documents have been marked as common, which your lordship has marked as ABC. And this is, Milord, if your lordship finds, Milord, it is they who have relied on it.
Because what the objection they have raised, they have relied upon the company proceedings.
That's the reason why I had not come yet, Milord. I'll come. I'll come.
This can go through.
Exhibit
D.
Huh? No. तो एक टायर कंपनी है ना फुल है It is the company petition. एक ही है. Exhibit. Mention the page number. 19 to 40. 42. 48.
Nineteen to 48 collectively marked as exhibit.
It is a simple. I think it is one of proceeding of the same. It's not collectively. All other documents are there.
Millard, it's a petition along with annexures.
Next, okay. Then collectively.
Collectively.
D collectively करो.
Can you tell my lord as to whether the defendant contested the said winding up proceedings?
Yes.
Yes, মানে কি? Can you tell my lord yes, the contest করেছিল কোনটা? Did they contest the proceedings? They
yes.
did contest the proceedings. Yes, they did contest the proceedings. Can you tell my lord whether they had filed any opposition affidavit opposing your petition to
Yes.
the winding up?
Yes, they file an opposition.
I'm drawing your attention to pages 60 to 78 of the judge's brief of documents. Can you tell my lord as to what is this document?
Affidavit in opposition on behalf of the defendant.
Can you tell my lord from page 76 as to who, from page 61 as to who filed the opposition and in what capacity? Page 61.
Mr. Kishore Agarwal filed opposition. Director of Railpal. Oh, defendant.
My lord, can the opposition go to it because this is also relied upon by them?
It's an
E. It is also annexers. Annexer is there.
No, my lord, there is no annex.
Only application. Only objection.
Only affidavit.
this one annexure.
একটা আছে
একটা
আমার
আছে।
এখানে জাজেস ব্রিফে নেই
77.
then it will go with annexure.
Collectively.
Up to 78.
Oh yes,
Up to 78.
Up to 78. Huh?
yes. পুরোটা collectively কত আসছে? কত আসছে? Was any reply filed by the plaintiff in the said proceedings dealing with the statements made in the opposition being exhibit? বলে দিন
reply file করেছে.
Yes, they have filed the.
I am drawing your attention to pages 98 to and 79 reply. To 97, yes, 79 to 97 of the judge's brief of documents. Look at this documents and tell my lord Is this the reply you are referring to? You have just referred to.
Yes, this is the reply.
Who has affirmed this reply and in what capacity?
Bipasha Banerjee, company secretary of plaintiff.
Is she still there?
Yes.
Are the contents of this reply true and correct?
Yes.
Well, this can also go in Millard as pleadings. And I believe
E.
annexer আছে তো এটাতে?
F. Annexers are there?
No.
Annexers are there?
Can you recollect as to what was the outcome of this winding up application which you had filed? একটু বুঝিয়ে দিন, উনি কিন্তু legal terms বোঝেন না।
अरे पूछो what order is passed in the company application?
File করেছি। না না, এটা তো একটা suit file করে।
79 to 97.
কি হলো, তার পরিণতি কি হলো?
ওরা মানে ডিফেন্ডেন্ট বোধহয় একটা সুট ফাইল করেছিল তারপর।
আর প্রশ্নটা বোঝেননি উনি। ওয়াইন্ডিং আপ অ্যাপ্লিকেশনটা কি? প্রশ্নটা যেখানেই আছে, প্রশ্নটা করে।
There is no document. It is a simple question. What does happen in the company application filed by the plaintiff?
কি
What was the
হয়েছিল যে
result?
মামলাটা ফাইল করলেন, সেটা হারলেন কি জিতলেন, কি হয়েছিল?
What was the result?
রেজাল্ট তো কিছু হয়নি।
I am drawing your attention to page 100 of the judge's brief of documents. What is this document? কি ওভার কনফিডেন্ট হয়ে গেলেন এই মুশকিল। ভাবে যে আমার মামলা আমি সব জানি।
What application?
জাজমেন্ট একটা।
It already disposed 7.
In which matter was this judgment passed?
Judgment.
ওয়াইন্ডিং আপ
Prepared an appeal. Appeal set aside. Prior to that,
Fine.
it was an order. They went to the stamping. One, 6 disposal, 8 disposal. 4.
হ্যাঁ, ওয়াইন্ডিং আপ প্রসিডিং এর এটা জাজমেন্ট।
Millard, this is the order of the court, Millard. It can go around. It's, I need.
Page number 27. You exhibit FG.
Milord, I have 3 more documents, Milord. Can I come back on another day?
Sir, 98 to 104.
98 to 104. I have only 3 more documents. I need only 15 minutes.
Take this.
Time fix koriye na ekta din.
Milord, it can be tomorrow, day after, whenever, because whenever is the shortest time, Milord, I am not.
Any day.
You also get ready for crossing the naive fix.
But he can conclude the chief
It will
thereafter.
take only 10 minutes. I'm telling you, Lord. I have only 3 documents to fill.
Kindly keeps it next week.
I am fixing not next week. I am because I don't think the date will be. मनोतोष कब डेट होगा? ये दे दो निको।
আমার ব্রিফ ছিল না? ও ও।
Students are appearing for the plaintiff. Students are appearing for the defendant. Full list of plaintiff witness is present. Examination chief continued, resumed during the examination. How many document? Exhibit D2, D2H, G2H. We are marked. We are marked. Full stop. Counsel for the plaintiff. Press for time to further examination chief of the plaintiff witness. Accordingly, chief is deferred. Let the matter appear on at 1st March.
First.
1st March.
My time.
The first it will be taken. Commercial, I am not fixing the time. It will take the first of.
May the witness step down from the.
Yes.
Possible matter, specific matter to the commercial is item number 3.
Yes. Yes, Mr. Banerjee.
Now, Lord, before resuming the argument on merits, one thing I can have to clarify in your Lordship's mind. Your Lordship's mind was from the very beginning, obviously, because of the argument advanced.
I have not made up any.
Oh, Lord, it is your
Yes, yes.
Lordship's. Your Lordship
Sorry.
did not make up your mind. But some mind, after the argument in advance, that is why your Lordship made a query to us for the purpose of clarification. Plus, if your Lordship made up your Lordship's mind, then your Lordship ought not to have disclosed us.
Correct.
that is the point. Lord, what was the argument? Argument was that the property, which was the subject matter of MOU, and one registered mortgage deed. Because there are total two mortgage deed. Lord, first mortgage deed was released.
Second came.
Now, Lord, so far the first mortgage deed releasing is concerned, Lord, there was no prayer that the releasing is illegal. Releasing should be restored. That is not their case.
No, they are
It is
relying
a
upon
simply
that
money
releasing
suit.
deed. They are relying upon that
They are
releasing.
relying upon that deed. This is simply a money suit.
Correct.
Now, Lord, the case made out the purpose of release, that it was fraud was practiced and all these things. Lord, these questions will arise. Pleadings are there. Evidences are there. All these questions will arise in a case when the first mortgage deed is challenged by saying that it was on the ground of fraud. But parties accepted and acted upon that.
No, no.
So far, the first mortgage is concerned.
With regard to the fraud, they have pleaded that what the amount you have received, that has been siphoned.
64,000 was siphoned. Siphoned.
To the
That is another kind of fraud. And that is also they have stated in their pleading and also evidence I can place before your Lordship that the release, deed of release could not have been made. Had they made representation in this way. That is their contention in the evidence as well as, my Lord, in the pleading. I will place before your Lordship on that. Now, Lord, what my submission before your Lordship is this, that so far the second mortgage is concerned. Second mortgage, according to them, it is a security for the transaction made. Now, Lord, transaction made and the character of the amount transacted, whether a date or not a date. That is the question, my Lord, for the purpose of granting a decree, money degree. If the mortgage money amounts to a debt, then, my Lord, based on that he is claiming, Lord, recovery of the money, then in that case, the redemption right is to be surrendered. That give me a degree on the basis of a money. Because the redemption in a case of a redemption degree, Lord, I have rights up to the final decree, Lord, up to the sale and confirmation of sale, up to appeal court. My right remains under Order 34 rule. Therefore, that right cannot be taken away. That is why, my lord, I have argued before your lordship. I need not repeat the argument. Section 68 for which I have given. Now, my lord, whether now today I shall have to satisfy your lordship. Today I shall satisfy your lordship from their own statement in the lord examination in chief. They admitted the memorandum of understanding and character of the money taken. 1 crore 25 lakhs, Lord, on account of sale of the property, part money, and another money, my lord, 6 months rent reserved. That was the purpose. Now, Lord, they have admitted, lordship, kindly come to the deposition of PW1.
Yes.
Lord, the examination in chief, Lord, question number 10. Lord, first of all, Lord, question number 10. After the site was approved by Hyundai Motors Private Limited, what steps did you take? We signed the MOU with the defendant number 1 because the defendant number 3 and 4 had told us that this property will be developed through defendant number 1 and then sold it and rented out as per agreement. The MOU states clearly the terms and conditions and money to be paid as well as the timelines to be followed. Therefore, they have agreed the terms and conditions of the MOU, and that was the contract. Then, my lord, 11, question number 11.
Yes.
This is the memorandum of understanding which is being executed on 4th of October 2012. Then, my lord, the documents at pages 13 to 24 being original and common documents marked exhibit so and so are tendered and marked exhibit B1.
B.
B, exhibit B.
Yes.
Then, my lord, in terms of this MOU, which was the obligation of the plaintiff's obligation was just to make sure that the money is paid as per timelines mentioned in the MOU. For that purpose, you have to pay money. The money was to be paid for 2 parts. The one part was for purchase consideration of the schedule, and the other part loan amount was given, and the entire schedule was mentioned in the MOU. Therefore, my lord, admit it.
It
Now,
is
Lord,
their case also.
Here, case also. Now, Lord, they say that this total amount paid by us, that is on account of mortgage. That is their case. Lord, this is a MOU is a registered document.
Correct.
The if anybody, what was our case, my lord? Our case is that mortgage deed is nothing but a security for the transaction made.
Unless and until you paid,
Yes.
or you complied with.
Yes, to be complied with. Lord, and my lord, it will appear from the recital of the mortgage deed. Now, Lord, if anybody wants to contradict, Lord, the terms and conditions of a registered document, then he must have to challenge that document. Otherwise, my lord, section 92 will be a bar. What is the exception of section 92 of the Evidence Act? Lord, exception to section 92 of the Evidence Act is that you cannot contradict the terms of the registered document.
No,
If you make out a case in the pleading contrary to the terms mentioned in the registered document, namely the MOU, are you entitled to agitate that issue in an evidence?
They are not challenging the either of the move, either first one or the second one.
Therefore, my lord, they did not challenge.
They are not challenging.
Therefore, when they did not challenge, therefore, because in that case, my lord, any contrary evidence contrary to the MOU will be inadmissible in evidence on record.
So, which, as per your submission, which evidence?
Yes,
is the
that is
contrary?
I am telling you, lordship.
Which evidence is
Yes,
contrary
that
to
is,
the MOU?
yes. Lordship, then kindly come to Lord paragraph, Lord 15, question number, Lord 13. The two parts, one part for the purpose of consideration of the schedule, and other party loan amount was given, an entire schedule was mentioned in the MOU.
That is itself.
Lord, loan amount, yes, that is in the schedule.
Correct.
Loan amount was, my lord, 75 lakhs.
Correct.
Now, my lord, your lordship, then kindly come to paragraph, my lord 15. After which, my lord, paragraph 15, after 2 lines, did the plaintiff comply with its obligation in terms of the schedule as recorded in relation to the date of 15th of October 2012? No. The money was given as per the date, after which only part of the loan was procured and nothing was done. After that, out of
29 quotas.
29 kathas was supposed to procure only, half was procured. Did the plaintiff make payment of entire amount on signing of the MOU? Yes, it was done by a single check drawn on Axis Bank.
Correct.
Now, my lord, this is clear from this evidence and clear from the pleading of the parties, both the parties, that parties have accepted the MOU, parties have accepted the execution and registration of the deed.
Correct.
Parties have accepted. There is no dispute
denial.
no denial with regard to that part. Now, my lord, my respectful submission is that thus, Lord, the payment that was made in terms of a MOU, not in terms of a mortgage.
But two parts, again, two parts will come. Not the total is the mortgage amount.
Not the total amount is a mortgage. No,
Mortgage.
2 crores. He said 2 crores.
Where
2
is the
crores.
mortgage?
Therefore,
Where is
now
the deed?
kindly come to the second mortgage. The mortgage.
Give the exhibits.
First mortgage.
Exhibit
first mortgage.
আছে এটা 12 অক্টোবর এটা তো রিলিজ হয়ে গেছে
এটা রিলিজ হয়ে গেছে
যেটা
সেকেন্ড মর্গেজ
Lord, I should not, Lord, release mortgage. I should not read the release mortgage. Lord, mortgage that was released, Lord, there are 2 mortgage.
That is the first of the 4th October 2012.
Yes.
Exhibit B.
সেকেন্ড মর্গেজ
Lord, Exhibit B is the memorandum of understanding,
Yes.
and simple mortgage, my Lord, Exhibit, Lord, that is 12/10/2012.
Yes, 12/10/2012, date of simple mortgage.
Date of simple mortgage.
Yes.
Now, my Lord, I need not read the first mortgage, or may I come back to the first, because it has been released. Once it has been released and it is accepted by the parties,
So no.
whatever recital is there, why should I take time?
So
of
we
the
cannot
court?
take into consideration.
Why should I take time?
So
of the
now,
court?
as per your
And why
submission,
should I argue on the basis of that?
that's why as per your submission, once that has been released, we cannot look into that.
Yes.
Now we have to go by the
second mortgage.
we have to go by the 12th October 12th.
Come back to the second mortgage.
Correct. Now come.
Now, Lord, second mortgage, my Lord, is dated 21st of November 2012. That is that's the second mortgage. Yes, 21st of November 2012. That is exhibit number E. Exhibit number E. Now, my Lord, come to exhibit number E.
Correct.
Lord, Judge's brief of documents, Lord, page 52.
I am having the original one.
Oh, original, yes, my Lord. Lord, 21st of November 2012.
Yes, 21st November 2012, date of
Page,
mortgage.
Lord, yes, page 56. Lord, the mortgage, Lord, Sabri Properties Private Limited, Fortis Export India Private Limited.
Yes.
Lord, 3445 was not a party to the transaction. More, they are not party to the
They are not the party subsequent because they have made a party because of the siphoning of the amount as per the case
Right,
made out by the
right, right. According to their claim that siphoning of the money, therefore
and they have
made a
utilized.
party.
That's why they have made a
But
party
they are not a contracting party
in
to
the party.
Yes, Lordship. Lord, now kindly come to page 56, my Lord.
Yes,
Lord, first part, second part is skip over.
correct.
Whereas the mortgagor developer is in the business of developing, selling, and relating of real estate, has identified the piece of land of freehold Vastu land measuring 14.5 kata more or less, situated at Dag number 260, jail number 51, Mauja Nipra, for development, for civil construction, for commercial use. Whereas the mortgagee desires of having a showroom space measuring 6,000 square feet in the said property, that the developer shall develop on the said land described above for commercial use. And whereas the developer are assured the mortgagee that the said commercial construction shall be developed by him within 6 months from the date of purchase of the land referred to above, and requested the mortgagee for financial assistance of rupees 2 lakhs. Lord, therefore, 2 crores, 2 crores. Lord, therefore, they are
decreasing the 10 point,
now, Lord,
10 times.
Lord, 1 0, 1 0, gulf of difference. 2 crores. Lord, therefore, these 2 crores was not exchanged. Money was not exchanged.
Request for
Practically,
mortgage for financial
request
assistance of 2 crore.
developed with it from the parts of the said and requested the mortgagee. Then, whereas the mortgagor developer have purchased the said piece of land from Vastu land measuring 14 kata 8 chotaks, more or less situated at Mauja so and so, from the lawful owner Sri Asit Baron Chatterjee and Sri Ajit Kumar Chatterjee by registered Bengali deed of conveyance so and so on 19th October 2012, duly entered in book number so and so, and the said mortgage developer became the absolute owner of the above land. And whereas the mortgagee, Messrs. Fortis Export India Private Limited, advanced lent herein Sabri Properties a sum of rupees 2 crores by creation of a registered mortgage on an existing property, for which a simple mortgage was executed in favor of the mortgagee, which was registered before the additional register. Lord, this is a very vital point, that Sabri Properties Private Limited 2 crores by creation of a registered mortgage on the existing property. Then, and whereas to complete the said construction work within the stipulated time, for which some funds are required to be arranged by the mortgagor herein, Sabri Properties Private Limited, and for which the said mortgage property, as per registered mortgage deed 12th October 2012, has been released by the mortgagee herein, that is Messrs. Fortis Export India Limited, in favor of the said Psychopar Private Limited. And whereas Psychopar Properties Private Limited is willing and ready to mortgage another property by deposit of title deeds specifically described in the schedule hereunder, and the charge and assured the same by way of a security for repayment or adjustment. Therefore, this is a security, not for the purpose of mortgage. Security and or adjustment the said amount of rupees 2 crores together with interest. And whereas the mortgagor Sabri Properties Private Limited at beneficial owner has deposited with the mortgagee, Fortis Export India Private Limited, the original title deeds of the property, which comprised in the schedule hereunder belonging to the said mortgagor, that is Sabri Properties Private Limited, with the intention to create security thereon for repayment of the adjustment of the sum of rupee 2 crores only with interest, if any, to the mortgagee, Messrs. Fortis Exports India Private Limited. Then
So this is a charge created. Charge is created on the
security,
security.
yes, whether charge is created or not, Lord, whether security shall be deemed to be a charge created,
Because,
even if it is, yes,
Because-
even if it is
because this is-
accepted, my Lord,
because
that
this is
charge
the
is-
registered document
yes,
and the registered deed is also given to them. So this is a charge.
yes, charge is created. Transaction with regard to 1 crore 25, that is for consideration of the money, that is a consideration for that. And loan, my Lord, with regard to 75 lakhs for the purpose of loan. Now charge is created in respect of 2 crores
2 crore.
by virtue of a security.
Correct.
By virtue of a security. Now, my Lord, your Lordship, then kindly come to the next. And whereas the mortgage Sabri Properties Private Limited as beneficiary owner has deposited with the mortgagee, what is private original deeds of the property, which comprised in the schedule hereunder belonging to the mortgagor, with the intention to create security thereon for repayment of the adjustment of so and so with interest, if any, to the mortgagee, Messrs. Fortis Exports India Private Limited. Then, my Lord, now the mortgage witnesses are under. Only the relevant part, my Lord, I may say before your Lordship, that paragraph 1, that in consideration of a sum of rupee 2 crores advanced to the mortgagor by the mortgagee, the receipt whereof. Lord, this is reality. In reality, it is not correct. In reality, our case is defense case is that in reality, it is not correct. Apparently, it is correct.
Because
What is apparent?
Yes, but what is your now that release has been taken, the receipt was there.
Yes.
That is continuation. That was in release. That is your submission.
Yeah, continue. That release, first one was released.
Because that 2 crore is in the first, with regard to the first release, first
Yes,
mortgage.
Yes,
Memorandum.
that was released.
That was released.
Released.
And this 2 crore is continuation of that MOU, but that was released.
That was released.
So you, as per your submission.
Another thing is, my Lord,
So
by
as per your
virtue of the-
submission, that has not been come, and the acknowledgement has not come in this deed.
Yes, Lord, appears from the document itself. My evidence, my Lord, it is a documented evidence. Oral evidences contrary to the document cannot be acceptable, inadmissible evidence, unless document is challenged. If I challenge the document, then section 92 will not apply. Will not apply.
Yet there is no challenge of the
He
document.
does not challenge the document. Document he has admitted. Now, any evidences I will place before your Lordship, some oral evidences, which is inadmissible evidence on record in view of 92. That is my argument, whole motto.
Relying of that document.
Line of that document. Line of that document. Now, my Lord, your Lordship, then because there was no transaction made here, therefore, what is apparent is not a real one. Now, loosely worded as SAM document. We have said SAM document. That is loosely worded. But court will, Lord, interpret the pleading by reading the pleading as a whole, not in isolation.
As a whole, along with the document.
Along with the document, not in isolation.
Not in isolation.
I said
none of that. The document cannot be read as isolation, or the pleading cannot be read as
absolutely,
isolation.
Lord, right.
Both the thing is to be taken
All
into
the thing has to
consideration
be taken
together.
into. Simply because I said that
Now you have taken that if this document has been taken into consideration along with the print, and that has been released, that cannot be taken into consideration.
Yeah.
Which has been released. So as per that, the 2 crore receipt is acknowledgement is not there. So that this document is only a sham document.
Yes. Now, Lord, your
As
Lordship,
per your submission.
and practically as per my submission, no transaction was held so far this party is concerned.
That's what I'm telling. So,
In this, yes.
so as per your submission, though it has been written in this document, there is no transaction.
Yes. Lord, then your lordship kindly see in the schedule without possession unto and in favor of the Forties Exports Private Limited and assured the same by way of a security for repayment or by means of other adjustment of the sum of rupees 2 crores together with interest thereon, out of which 75 lakhs will carry an interest 12% per annum, equivalent to 1% per month. Now, Lord, these shows in the plain they are claiming that 12% interest at the rate of 12% interest on 2 crores. Document says that 75 lakhs will carry interest 12% interest equivalent to 1 month. Lord, pleading contrary to the document.
Okay.
They are admitting the document. The terms and conditions of the document is adjustment of the sum of rupees 2 crores together with interest thereon,
Correct.
out of which 75 lakhs. Therefore, 2 crores out of which 75 lakhs will carry interest 12% per annum. Now, Lord, they are claiming 72 crores, 71 lakh and odd amount on account of 12% interest on 2 crores. Is it permissible? This is my argument, my Lord. Then, my Lord, next. Then how it will carry? Mortgagor developer has already agreed and covenant with the mortgagee to pay or cause to be paid to the mortgagee the principal sum aforesaid together with interest on or before completion of 11 months from the date of payment. Lord, together with interest means restricted to the earlier clause.
Principal sum aforesaid together with the interest thereon.
That means, Lord, earlier clause.
Correct.
That means interpretation of the document has to be made. Lord, rules of interpretation of a document. Lordship knows the entire document has to be read as a whole. Like in the pleading, entire document to be read as a whole. 11 months from the date without any delay or default. And this deed further witness that it is hereby agreed and declared by and between the parties. And in case the sum of rupees 2 crores with interest thereon at the stipulated is not paid within the time, and in the manner as aforesaid, it shall be lawful for the mortgagee to enforce the mortgage and to cause property or the portion thereof to be sold and appropriated, use such sale proceeds towards the satisfaction of the mortgage debt. Therefore, my Lord, this was clearly mentioned as a mortgage debt.
Yes.
It was treated as a mortgage debt, although it is as a security, but by contract it was treated as a mortgage debt. And how the mortgage debt can be recovered? By selling the property. Then, my Lord,
Yes.
however, in the event of any shortfall or deficiency should claim has not satisfied from the sale proceeds, as aforesaid, the mortgagee shall be entitled to recover unrealized balance amount separately.
From the mortgage.
Lord, what does it mean? Means, my Lord, that they are to, in terms of the contract, they are to come by two process, either by selling, by suit for sale of the mortgage property. If it is a suit for sale of the mortgage property, then he cannot file a suit in the blood original site because property is situated in Howrah, because enforcement of the mortgage. Blood limitation is 30 years according to the Limitation Act. Lord, it is not a case, Lord, it is but by limitation. Therefore, it will be an inequity Because you have taken money, Mr. Banerjee, your client has taken money 2 crores, and in this way, if I accept the argument, entire money will go. No, it will not go because 30 years limitation is there. You have chosen that.
Yes.
Next, my lord. However, that in the event of any shortfall, my lord, this will clarify the position. Then now further witnesses that mortgagor developer thus hereby assured the mortgagee, notwithstanding any act, deed or thing executed, performed here before, suffer to the contrary, the mortgagor has good title, full power, absolute authority to charge, assure, and mortgage the said property in the manner hereafter effected, and that the same is free from all encumbrances and attachment, and mortgagor shall solely responsible to indemnify and indemnify the mortgagee under all circumstances from the memory loss or damage. Lord, indemnification will arise in a case of defect of title.
Correct.
Indemnify, this is an indemnified clause, my lord. Lord, Supreme Court judgment on the basis of this, my lord, Lordship knows that when there is an indemnity clause in a document, that indemnity clause will apply only in a cases when the defect of title is found. Lord, here there is no case of defect of title. Therefore, he cannot enforce by saying that it is an indemnity on the basis of indemnity clause. I'm entitled to enforce the contract. This is simpliciter a money suit. Therefore, my lord, enforcement of the debt by executing the mortgage deed, by enforcing the mortgage deed,
Yes.
Lord, shall be deemed to be a suit for 2 classification, my lord, having 2 classification under the law. First classification is suit for foreclosure. Second is suit for sale. Lord, this has been emanated out of section 60 of the Transfer of Property Act.
Correct.
This is inbuilt under the Transfer of Property. You cannot bypass it for the purpose of securing the jurisdiction of the original site.
Yes.
Now, my lord, your lordship, then kindly come to, Lord, these are the things. And my lord, 14 katas, mortgage 14 katas, title, placing title deeds, Lord, depositing title deeds also.
Correct.
Therefore, my lord, mortgage by depositing title deed means equitable mortgage. Secondly, simple mortgage by executing a mortgage deed, registering a mortgage deed. Lord, there is no prohibition under the Transfer of Property Act that simple mortgage and equitable mortgage cannot be done simultaneously. Is there any prohibition, my lord, under TP Act? No. Therefore, this is proper, not illegal. He deposited title deeds. My client has deposited title deeds. In respect of which property? In respect of 14 katas and what?
Correct.
What is the MOU, my lord? MOU is 29 katas to be purchased. His allegation is, I committed a breach of the contract. If I commit a breach of the contract, what is your remedy? Your remedy is to sue for a specific performance of contract.
That you are already argued.
That I have already argued.
This is not the
I
case
need
of,
not repeat.
this is not the case of a specific purpose.
It is not a case of that nature. Therefore, it is restricted to this. Whether I have purchased the property or I have not purchased the property, I have committed a breach of contract or I have not committed a breach of contract. These are all relevant, irrelevant, Lord, having regard to the relief claimed in the suit itself.
That's
for
why.
the purpose of ipso facto suit
That's why-
for recovery of money.
Because you have started your argument because this is not the case of a specific performance. They didn't want the specific performance of this contract.
Right, my lord. Now, my lord, kindly come to the evidence part. Lord, paragraph Lord 15. Schedule as recorded in relation to date of 15th of October 2012. So money was given as per date, after which only part of the loan was procured and nothing was done. After that, out of 29 kathas that was supposed to procure, only half was procured. The plaintiff make payment of the entire amount of rupees 2 crores on signing MOU. Yes, it was done by a single check drawn on Axis Bank.
So that's
Therefore,
why
transaction was entered into in terms of a MOU. Now, my lord, I shall come back where MOU was executed, because it is a case of a damages also for breach of contract. 300 crores. Lord, damages for breach of a contract, Lord, has to be instituted where the contract was executed and executed. Where the transaction in respect of monetary transaction was made in a place that was the cause of action for the purpose of filing a suit.
so that you have already argued.
No, that I have already argued that part.
Because the money was paid with respect of that land. The money was paid with respect of the property in question, which was lying outside of
No,
the
no,
jurisdiction.
my lord. Money practically, that argument, my lord, I was on that day fool, my lord. Today I am wise.
Now you are changing that.
No, not changing. Not changing. My lord, I am saying that when I have read the entire evidences, my lord, I have seen that the transaction MOU, the release deed as well as the mortgage deed was executed, Lord, and contract was entered into. Everything was done in the office at VIP Road of the plaintiff. The evidence was there. Lord, I shall argue on that basis that the suit for recovery of money is not maintainable in the eye of law on that count. So far, the
Cause of action.
because breach of contract, Lord, where the suit is to be filed. Lord, our division bench presided by Honorable Justice Anil Sen has held that long back. I will place before your lordship that judgment. Let us, Lord, place this, that payment of the entire amount of rupees 2 crore signing MOU. Yes, it was done by single check drawn on Axis Bank. Then, my lord, your lordship come to Lord paragraph Lord, paragraph, my lord, 22. The first one of the mortgager is the defendant number 3, Devanand Gupta. The signature of the mortgagee is that of my brother, Mr. Rishabh Himmat Singh, who is also a director of the Fortis Export India Private Limited, the plaintiff. Then, my lord, this document was tendered at Exhibit C. Then, my lord, kindly skip over the.
What about the question number 18?
Question number 18.
Yes. What about
Now, at page Exhibit B, you will find the expression on registration of mortgage. What mortgage is being referred to in this document? The defendant 3 and 4 wanted money to start procurement of the land and construction. In this regard, we have given them 2 crores against which they agreed to mortgage the property of the defendant number 2. Lord, there was no document with regard to 2. Document is exhibit number which I read it. Lord, the second document of
Exhibit E?
Exhibit E relating to the MOU transaction, not relating to this transaction. This is contrary to the, my lord, contrary to the evidence.
No, that's why.
That is why, my lord, I am drawing. Witness may lie. Document must not lie.
So
You accepted the
so
document.
as per the evidence of the witness, this 2 crore shifted in the exhibit E. The 2 crore which was made in the exhibit B, shifted in exhibit B.
Lord, Lord, with regard to that part, Lord, my respectful submission that it was not shifted. Money cannot be shifted. Once the transaction is there, transaction is complete.
Transaction continue. As per the, because only that has been released, the transaction as per the exhibit B that continues.
Transaction remains, not continue, my lord. Transaction remains. Transaction remains. Transaction cannot evaporate. Transaction remains. But that for the purpose of securing that amount, Lord, second mortgage was executed. First mortgage was released, second mortgage was executed. Now, second mortgage was executed not in respect of 29 kathas, but in respect of 14 kathas.
Yes.
Lord, that is for the purpose of security. Now, Lord, therefore, this cannot be that 2 crores was given to the defendant number 2. Lord, there is no document that 2 crores were given. If I say that 2 crores was treated as a transaction in respect of Mo, Lord, that cannot be done. Mo is accepted. Mo is implemented. In terms of the Mo, they accepted and acted upon it. Now they cannot say that the transaction in respect of the Mo goes back to the
Exhibit B.
Exhibit B, then Mo is redundant. Mo has given a go by.
That is your sum. Yes.
Then question of Lord committing breach of Mo does not arise in that case. Parties, it is not the case of the respective parties of the plaintiff that Mo is given a go by.
Yes.
Once the transaction is made, Lord, monetary transaction, living, that is living transaction, over, dead. Transaction is, Lord, full stop is there. Lord, then that is continue. That is, Lord, that remains. Liability remains. Once I took the money, liability remained. I never argued, my Lord, before your Lordship, the liability did not remain. I say liability remained. But the procedure for the purpose of recovering liability,
that is wrong,
has been engrafted by the legislature. You cannot go bypass the legislature.
The procedure adopted by the plaintiff is not in the correct.
Legislative prescription is there. How can you bypass the legislative prescription?
Okay, next.
Lord, then your Lordship kindly come to Lord, paragraph, my Lord, 28. What happened thereafter? After that, the defendant number 3 and 4 approached us by saying that we need more to acquire the land and start the construction. Hence, they would want us to release the mortgage of the defendant number 2 so that they could raise money from the bank by way of a securitizing the rents.
So no
the grounds for the purpose, no, grounds for the purpose of releasing the first mortgage,
correct,
which the defendant number 3 is getting from the tenants. Did the plaintiff agree to the proposal of the defendant number 3 and 4? Because of the fact we had a strictly timeline to meet and to ensure that the project complied on time, we had no option but to release it so the same could be done. Then, my Lord, your Lordship, kindly see then release of the mortgage, my Lord. Paragraph 30, my Lord, accepted.
correct.
The grounds for the purpose of release of the mortgage, Lord, in paragraph, my Lord, 29.
Yes, it is the case. It is the case of the plaintiff. It was released.
Yes, now very nice thing, my Lord. Then how they are disputing this? Lord, Lordship, kindly come to the next. Then, my Lord, paragraph 33. Lord, I am reading only with regard to the releasing of the mortgage and the mortgage part. Only this relevant line. After the release of the mortgage, what happened? After release of the mortgage, they mortgaged another property. Lord, because, Lord, I have already argued before your Lordship, the property being one, which was purported for the construction of the said showroom and workshop, I would like to mention here that this was only half of the 29 kathas that was procured, which was mortgaged to us. Which was mortgaged because that was belonging to the property which was mortgaged by the first deed. That was belonging to the different number 2.
Yes. That is the half.
That is half. That is half.
Correct.
And my lord, that then my lord was mortgage. Then your lordship kindly come to my lord signature with regard to 35, my lord, forget about it, my lord. Not forget, my lord, your lordship with regard to signature, right? That document was proved, my lord, by a direct evidence. Then, my lord, say 33. Contents of the document are absolutely correct. But documents are admitted.
That's why document is not disputed.
Documents are admitted.
Because they are relied upon and you are also admitted the doubt.
Yes, documents are admitted. Lord, then, my lord, paragraph, my lord, 38. After the mortgage dated 21st of November 2012, in respect of the half of the land was created, what happened then? The rent was supposed to be scrutinized, securitized by the defendant number 2, which never happened. Neither was the balance portion of 29 kathas procured, nor any construction started on the land as per the guidelines. Lord, that is their case in the pleading also.
So that is the violation of the
that is the violation of the
violation
MOU.
of the
Violation of the MOU. Then, my lord, paragraph, my lord, page 43. I am showing a letter dated September 11, 2014.
But Mr. Banerjee, as per the question 39, can you proceed with the matter?
As per 39.
Answer to the 39?
Yes, that is right, my lord. That is right.
It is on evidence.
Evidence. That is right.
Think over it.
Lord, then kindly give me, I shall retire from the case. I should not. Lord, I should not, my lord. Lord, it is a fact, my lord. I
had
tried
indicated, my lord,
yes.
I don't take such objections, my lord. My learned friend is a senior colleague. I don't take such objections.
But I should
He
not.
was aware he is appearing for
that
day
is
one.
Right. That is right. It is his goodness, my lord. I respect him.
Lord, let him end it,
senior
my
to
lord.
me. But I respect
My
him.
arguments were completed in January
Lord,
2023.
I fully respect him, my lord. I never, Lord, I know him, my lord. I respect him also. Right. He would not object it. But as a counsel, my lord, it would not be possible for me, my lord, after this.
That to senior.
That is my lord. When your lordship pointed out and it was omitted by me, my lord, during the Had it been brought to my notice earlier, and this is a fact, my lord, no doubt about it. We tried at my level best, my lord, to settle the dispute. Because after all, they paid the amount.
Okay, I am adjourning.
No,
It is fixed today or tomorrow also.
Yes, my lord.
Fixed tomorrow also. Talk to me if Mr. Chaudhary is not having objection.
But I don't have any objection. Let him finish it. Lordship will record it.
I will record that.
Yes, yes.
I will
I have
record.
no objection. I indicated earlier also.
If Mr. Chaudhary will not object, then I will record that objection.
Yes, yes. Let him finish it, my
Lord,
lord. It is
but-
now on the
but-
verge of conclusion.
But he
my
may
client
not raise
will-
objection, my lord. He may not raise objection, but as an advocate, my lord, in this institution, Lord, my duty is there. Lord, it is my duty, my lord. I am your lordship kindly give me after 10 days time so that I
Then
can.
new advocate will come again. He start from the one.
My lord, Lordship
Zero.
has seen, my lord,
That is the
January
problem.
2023, my
That is the
argument
problem.
concluded.
That is the
1
problem.
year,
Mr. Siddhartha Banerjee was there. Thereafter, his junior has, my lord, 10 adjournments on one pretext or the other.
Then why you have taken this in the evidence? You should not have.
And I
No,
have
it is
nothing
the
to do.
witness.
It's the
He has not taken. It is a witness.
It is a witness. I have not
Witness has
argued this
stated.
point. I don't argue any point of
And when you are
personal
not
prejudice.
present, when I have taken the argument of Mr. Chaudhary in your absence, he has not pointed out this
No,
also.
he did not point out.
I
He
have
has
not
not
argued
pointed
to.
out.
And my lord, it is the
Only
did
when
not-
you started,
Lord,
only
what my submission is, my lord, he did not say, he did not argue, but his client said in the evidence. That is the whole difficulty. His client said, my lord.
Okay,
Lord,
let
his client said.
tomorrow come, let us see. What will
Lord, tomorrow I have some difficulty, personal difficulty. Lord, on Monday, your lordship can keep it.
The Lordship had kept 2 days, my lord. He would conclude
so that
today
you
and
can
I would
conclude
give
it.
the reply because
no,
my
I
opening
wanted to-
argument was concluded in
I have
January
fixed 2 days,
2023.
Four,
Complete it,
four,
my lord.
5 days you are argued the matter. 2 days I have fixed for you so that
Lord, I wanted to, my lord, complete it, my lord. I want, my lord, to complete it. Because of this, my lord, I am in difficulty. Lord, when your lordship pointed out to me, it is my duty. Lord, not that, my lord. Lord, my intention is to conclude it.
conclude. Mr. Chaudhary is not
Lord, client should
objecting for
not
that.
be.
I will record the order. I will record that.
Let us talk to Lord let him talk to the other side, whether other side has any objection to that.
But I am giving my client has no
All
objection.
right, my lord. Then I shall talk to my client, my lord.
But objection is from their side only. What your client will do? If Mr. Chaudhary is telling that he has no objection, I will record that. Future, if the advocates will change also the
Then in that case, no difficulty.
No
Yes,
difficulty.
Yes, all right, my lord.
the order will be on record.
But Lord, as a
And you
learned
80%
advocate,
you are
my lord,
argued.
he may not say this. It will go to appeal. Appeal court said, why Mr. Banerjee argues?
The order, you show the order.
Lordship will record. He
I
will
will
not have
record.
any
He will
problem. I will
record.
not
I
put my
pointed out,
learned
but,
friend into any problem.
During the evidence, this court has pointed out, but Mr. Chaudhary has not raised any objection and it may continue. Let it be continued.
Lord, let us think over it, my lord. Your lordship kindly fix it on Monday, my lord, so that I can call my client also. Lord, I am not taking, because tomorrow is the Friday. I am seeking time on 5th, my lord. 5th.
You are going.
No. I shall be with effect from 6 onwards for 4 days. Yes. Lord, second appeal is fixed. Second, but 5th day was not the 5th day. Subject to my lord's acceptance, my lord.
Manutosh. So I am fixing a matter. When Monday you will be available? Only I will fix a matter. You inform this court whether you will appear or not. Mr. Chaudhary has given his intention. He will not raise an objection. I am also telling if Mr. Chaudhary, this court will record that order. Instead, if conscience is allowing, then I am fixing on Monday. Take instruction. Then I will fix a date continuously. The matter can be fixed.
Lordship.
So That is Monday subsequent when
আচ্ছা, আপনি ভালো মানুষ আছেন, আপনার জন্য আমার কি
আমার ক্লায়েন্টও ভালো মানুষ।
হ্যাঁ, তা ভালো
Feb-
মানুষ বলছি তো,
February
ভালো
ভালো
and
আপনার ক্লায়েন্টও ভালো মানুষ, আমি জানি তো। That I know.
দিনে দিতে পারতো।
হ্যাঁ, নিতে
12,
পারি।
13.
আপনি তো কমন অ্যাডভোকেট ছিলেন।
Other matters are not there.
চুপ করা।
This matter must be. 12 is okay. 12 is okay. And another.
কবে ডাকলি?
22nd. And then 26. So I am doing one thing. I am fixing on Monday only for your instruction.
Lordship.
And I am also fixing 3 dates. If you will continue,
And
we
on that
can't
day, my
change.
lord, it will be
I am fixing
recorded.
other 3 dates so the matter can be disposed.
Because when they are not objecting to this, it may be recorded so that I can continue. Let us think over it.
Suffering for the defendant. Police counsel for the defendant has argued at length. But paucity of time, the argument could not be completed. Mr. Banerjee, non-senior advocate appearing for the defendant, submit that.
কিছু মনে করবেন না দাদা, কিছু মনে করবেন না।
He will take appropriate instruction from the client, whether he can continue with this brief on behalf of the defendant attacker and prays for fixing the matter as to be mentioned on 5th of February 2020. Let the matter fixed on 5th February 2024 for taking appropriate instructions by Mr. Banerjee. With regard to hearing of the matters on merit, let the matter fixed on 12th February, 22nd February and 26th February.
12 February. দাঁড়াও 1 মিনিট। এই 1 মিনিট দাঁড়ান, 1 মিনিট দাঁড়ান।
কি?
হ্যাঁ, ঠিকই আছে। Yes.
Yes.
This is my 34.
Reply.
I know, my lord, I am in reply. But your lordship, my lord, has given me the liberty to, my lord, cite cases, my lord, if we. On facts, I will not, my lord. But there are some things, my lord, which was not argued. And what fell from your from my learned friend, my lord, I am going to take that as a lead. Children.
Have you informed about the citation which you are relying upon now? Have you
I have not.
not? Okay.
But I will today.
Okay, continue.
My lord, your lordship has heard it in the first stage, but my lord, this was perhaps not brought to your lordship's notice. My lord, this is 34. My learned friend, my lord, has shown how, my lord, I have not given him the site and how that, my lord, caused him inconvenience to complete on time. When he did not, he got extension. But, my lord, he has ultimately completed and now he claims, my lord, made certain claims for enhanced rate, idle charges, etc., which, my lord, the arbitrator has allowed. And the arbitrator has held that, my lord, I was at fault for not giving the space to him, which is why, my lord, I am at fault and he is entitled to damages. This was what was shown. Lord, in 34, my lord, my humble submission is that I have to show that when the arbitrator has allowed these claims, what is the reasoning behind what, on the basis of which he has allowed. He has to do it, my lord, within the periphery of the contract. I am going to show, my lord, from the award itself, not referring to anything else, that the arbitrator has held that the contract stood expired and terminated in 1999. From the 2 years period, my lord, was the contract, initial contract. He says there was no relationship between the employee, the employer and my learned friend. Contract became void. No terms are applicable. Terms have become ocious. And, my lord, he says there is breach of a contract which does not exist and applies section 70 of the Contract Act. So, my lord, he has allowed these compensation on a principle of quantum merit, which is a third limb, my lord, and an equitable principle. Nothing, my lord, on the basis of a breach of contract. That is, my lord, in my humble submission, would be perverse, patent illegality, and, my lord, the test, my lord, that is laid down in associate builders, because it is an admitted position that we are governed by associate builders today.
But the main argument, Mr. Dutt has argued that you have taken several grounds, but what reasons?
Yes, I have taken note. My learned friend said, I have not even mentioned these grounds.
Correct.
I will show, my lord, that I have. Before that, my lord, I have to show, my lord, certain paragraphs from associate, where so we know, my lord, where we are traveling. The periphery, my lord, the boundary, my lord, let me create for myself. Kindly, my lord, ekbar associate ta dao. This is the law, my lord, which has to be applied today. Kindly, my lord, takes a few paragraphs, my lord, just to refresh. Page paragraph 14. Paragraph 14, my lord, section 34 has been set out. This is, my lord, pre-2015 amendment.
Yes.
My lord, I will be relying, or I want to, my lord, come under 34(2)(a) subsection 4, which is the arbitral award deals with a dispute which is not contemplated by or not falling within the terms of the submission to arbitration, or it contains decision on matters beyond the scope of submission. This I am relying on A, because the section 70 plea on which the claim was allowed, my lord, was not even pleaded, my lord, in the statement of claim. Statement of claim proceeds on the basis of breach, consequential damages under 73. Arbitrator has allowed the claim, my lord, on an equitable principle of section 70. So, my lord, this ground. Next, my lord.
Ground 34(2).
A subsection 4. Next page on the next.
Arbitral deals, yes.
Yes. Next, my lord, I come. B, subclause B(2). The court finds that the arbitral award is in conflict with the public policy of India. Now, public policy has been given a wider meaning, my lord, in associate, following ONGC and SAW pipes. Which, my lord, I have to bring it to your lordship's notice what public policy includes. Kindly, my lord, takes in this context paragraph 19. When it came to construing the expression public policy of India contained in 34(2)(b)(2), ONGC and SAW pipes held at paragraphs 31 and 74. Therefore, in our view, the phrase public policy of India used in 34 in context is required to be given a wider meaning. It can be stated that the concept connotes some matter which concerns public good and public interest. What is for public good or in public interest, or what should be injurious or harmful to the public, etc. My lord, I am not on that. Kindly takes the last 3 lines. Such award, that same paragraph 31. Such award or judgment or decision is likely to adversely affect the administration of justice. Hence, in our view, in addition to the narrower meaning given to public policy in Renu Sagar, it is required to be held that award could be set aside if it is patently illegal. So, public policy now includes patently illegal. The result would be award could be set aside if it is in addition patently illegal. Now, this illegality, my lord, also must go to the root of the matter. Correct. Kindly see the last 3 lines.
Yes.
Of the matter, and if it is of trivial nature, it cannot be held that the award is against public policy. Award could also be set aside if it is so unfair and unreasonable that it shocks the conscience of the court. Such award is opposed to public policy. So, my lord, I am going to show that this illegality, my lord, by allowing the claim under section 70, which was not the case in SOC, my lord, is an illegality which goes to the root of the matter. And, my lord, it should shock the conscience of the court, because when the arbitrator says there is no contract between the parties, the contract expired, and, my lord, it was not a gratuitous act, my lord, beyond the contractual period on equitable principles when the award is granted, my lord, that should shock the conscience of the court.
Where is that
Yes.
observation of the arbitrator?
Yes. And there are others also which says errors apparent on I'll just indicate the paragraphs, my lord. Paragraph 20, which says that ONGC and SAW pipes has been consistently followed till date. Then, my lord, para 21, Hindustan Zinc also, my lord, says, last 3 lines, SAW pipes is clear. Court can interfere with it on the ground that it is patently illegal. And, my lord, now contravention to the substantive law of the land. That is an additional ground I will be relying on. Para 29, it is clear that juristic principle of a judicial approach demands that a decision be fair, reasonable, objective. Para 31 is perverse and irrational. And substantive law of the land, my lord, is paragraph 42. 42.1, which, my lord, considers the previous act's judgment where section 30-34 where error apparent, my lord, was the consideration. 42 says in the 1996 Act, this principle is substituted by patent illegality. This principle means, my lord, error apparent on the face of the record of the award. And 42.1 is a contravention of the substantive law of India would result in the death knell of an arbitral award. So if today I can show what the arbitrator, my lord, has passed is really contrary to the substantive law of the country, my lord, then the award must go. I'll my lord, do that.
That is the settled position. If you satisfied,
Yes, I am going to do that. And these grounds, my lord, I have indicated. I'll just indicate, my lord, in my section 34, page 18, 20, 23. So a point was taken that these grounds are not there, my lord. That is perhaps not correct. Right. Sir, kindly takes my 34.
Page 20.
Yes. Section 34 application. Which is in the paper book. Ground number 7. Has your lordship got the 34?
Yes.
Yes, so I'll just indicate. Ground, my lord, 7, page 18. It says decision outside the contract. Ground number page 20. Yes. Page 18, ground 7. Ground 4. Errors apparent on comparing the award to the terms of the contract. Then, my lord, page 20. Page 19 also, ground 9, 10. Decides matters outside the jurisdiction, disregards the law. Ground 20, page 20, ground 18. For the impugned award is contrary to the substantive law of India. Kindly notes that, my lord. I have taken that point.
20.
Page 20, ground XVIII, mane 18.
18.
Then, my lord, 16 also, ground 16. Impugned award is otherwise bad in law and contrary to the public policy and or in conflict with the laws of the land. Page 20 itself, ground 16.
Yes.
Then ground 19, perversity, vitiated by perversity. Then, my lord, 34, at page 23, errors apparent on the face of the record. 36, bad in law, contrary to public policy and provisions of the law. So, my lord, I have taken. Now in 34, my lord, I have to, my lord, really take the point and not in the nature of application should not be
They
the
have
nature of.
stated you have taken under what pretext? You have not described patent illegality as a whole. Which portion, what evidence, what the evidence has been considered which is a patent illegal, that has not been described in your ground. If simply you have taken as a whole, that is the patent illegal. You have not described as per the submission of Mr.
Yes,
Dutt,
but we are
whatever,
subject to
because
correct.
you have taken all these things, but you
Yes.
have not described which finding is perversity, which finding is the patent illegal, which finding is the about the contract, that you have not
Very
described.
well. My lord, I will check that. And also, my lord, if I subject to my lord correction, if once I take the pleading, then my lord, of course, on the basis of pleading, my lord, I can make submission and show from the award itself.
Okay, sure.
I'll show from the
How will I
award
deal with
itself.
How will I deal with it?
No, I can understand my learned friend's agitation because
Because Mr. Dutt can, it is not a 2 or 3 page award.
So, but thing is that if I am
it is a 95-page award. Reasoning part is, my lord, 17 pages only.
Whatever it is, but if it is, you are telling that the patent illegal, which portion is the patent
Why?
illegal?
then
It
one
is a
line will
perverse.
suffice
It
that
is a
the award
perverse.
is bad.
Which portion is the perverse?
Why?
Now he has stated that he has stated that the agreement is terminated.
Yes.
Over. But subsequently, under section 17, he has come to the conclusion and passed an order. Where
Yes.
is that
Where
portion?
is
You have
that?
not stated that.
In my award, in my petition.
In your grounds.
Grounds petition is
In your grounds, you have not stated all.
to deal with it.
Very well, my lord. I am checking, my lord, but
That is the main argument which Mr. Dutt has.
I have taken the ground, but I have not elaborated
No,
perhaps
that's
what you are
why,
saying
see-
or what they are saying. I have not elaborated.
Which portion?
Which portion of the award is bad? I am saying,
Which portion of the finding? Which portion of the finding it is a patent illegal? Which
Milord,
portion?
I would then say today, Milord, the entirety is patent.
Okay, no, you argue
Then that is something that he cannot find. I'll say entirely bad. No portion, no partial, everything is bad. The foundation is
each
bad.
and every word is so.
Because if the foundation is wrong, then Milord, the award cannot stand on the legs when there is no foundation. If I can show that.
Okay, you
Yes.
argue on your way. No problem.
Kindly, Milord, takes. Now, Milord, I am relying on this supplementary affidavit which contains the award. If your lordship is seeing the paper book, then it's a
Citation.
pages won't matter.
Yes.
Now, Milord, has your lordship got this up? Yes. Milord, so from page 1 to page 78, Milord, or 73 internal page, everything is narration of facts. The page 7, internal page 73, Milord, at the bottom, he starts discussion. I have considered. Now, Milord kindly takes page 80. Is your lordship looking at that black pen marking or the internal page?
And both can be, because internal is also there, black is also there. 80
Very
is
well.
the 85.
Yes, then I am going to, Milord, take your lordship to page 89.
89 of
Or the black one.
running page.
Yes.
Internal page 89 of the award.
No, running page. Internal is 84.
Yes, 89.
Yes. But Milord, before I show the reasoning, I must show what was argued. Kindly, Milord, takes page 12 and 13 first. Internal page. Kindly, this is very important. Bottom. On 12th December 1999, the claimant wrote to the executive engineer after the expiry of the stipulated period, requesting the executive engineer to extend the contract for the time being.
Where from your reading?
Milord, the internal page 12, last 5 lines.
Internal page 12, last 5 lines. On
Yes.
27, 12, the claim, yes.
Yes. stipulated requesting the engineer to extend the contract for the time being for a year. It is contended that this contract was executed in the name of the Governor of State of West Bengal, which is governed under Article 229 of the Constitution of India, by which the period of contract was agreed upon in the name of the Governor, and which period cannot be extended without concurrence of the Governor. It is contended that the contract period expired, making all the clauses of the contract inapplicable to either of the parties. No supplementary contract or agreement was executed by and between the parties after the expiry of the instant contract in the name of the Governor. There was no provision in the contract for extending the contract after expiry of the contract period initially agreed upon, and as such the clauses of the contract became odious, inapplicable against either of the parties, and the rates as well as the execution of the work as agreed were not applicable after the contract period, and accordingly the claimant contractor was entitled to escalated rates for executing further works beyond the stipulated contract period upon in the absence of a fresh formal contract. The execution of the work by the claimant beyond the contractual period is well protected under Section 78, that the obligation of the person enjoying benefit of non-gratuitous, that should be 70 really. It is contended further by the learned advocate for the claimant that the claimant is a contractor working for gain, and as such, works executed by him or them beyond the stipulated period of the contract was not gratuitous work, and the respondent without any objection reaped the benefit of such work and thereby made itself liable to compensate the claimant to the extent of the benefit enjoyed. Section 70 of the Contract Act contemplates equitable principle to prevent undue enrichment. This was the argument. Enrichment by any party. Here the respondent for the works made by the other party. Here the claimant for the works done to the benefit of the respondent. It is contended further that the juristic basis of obligation embodied in Section 70 is not founded on any contract or tort, but upon a third category of law, namely quasi-contract or restitution. It is strongly contended by the claimant's advocate that the person enjoying the benefit has the option to refuse the enjoyment of benefit, but here the respondent did not do so and made them liable to make payment to the contractor for the works executed. Now, my lord, there's several discussion on this repeatedly. Finding. Kindly takes, my lord, page 70, page 89, running page 89. Whereas the state has said that no, this is not correct. Arbitrator said there was no contract. This is, my lord, within the reasoning, internal page 84. Kindly comes to, my lord, last few lines. 1, 2, 3, 4, 5, 6, 7, last 7 lines. Has my lord got that, my lord? It is not fully understood as to what the learned advocate wanted to convey by the argument. This is my argument, that the contract was one contract which was alive beyond the stipulated period, and in this view of the matter, the learned advocate argued that the respondent did not breach the contract. So we had argued, my lord, that the contract had survived. In my view, no contract can survive after its expiration, and extensions of the contract has to be given before expiration of the original period. Apart from, then next page, page 90, second paragraph, which starts with the word next. Next, on the one contract theory propounded by the learned advocate for the respondent that the contract was one contract which was alive even after the expiry of the contractual period, that is after 22nd December 1999, page 85. It is clear that the contract expired with effect from 23rd December 1999 and nothing could be done on an expired contract. The conditions of contract provide that a contract has to be made in the name of the governor, and here in this case, no such contract was made for the work beyond the extended period in the name of the governor. Moreover, the contract provides that the respondent could levy penalty in cases where the respondent finds that the quantum of work was not executed within the required time. In this case, not less than 5 extensions were given to the claimant without levying penalty, and no penalty was levied for execution. Although the respondent continued to play the old disc that the claimant breached the provisions of the contract by not conforming to the terms and not executing the works within the time frame. It is again argued by the learned advocate that the claimant never informed, etc. Now, my lord, kindly takes page 93, internal page 88. On the last paragraph, on the point that the contract was one contract lasting after the expiry of the stipulated period as submitted by the learned advocate for the respondent, it appears that the original contract expired on 22nd December 1999, and after that certain works was done under certain understanding between the parties, but no formal contract was executed in the name of the governor of the state, and as such it cannot be said by any stretch of imagination that the original contract was kept alive after its expiry, and in that event I am unable to see eye to eye with the theory of existence of one contract theory propounded by the respondent. The continuance of the execution of the work after the expiry of the stipulated period under the instruction of the respondent inured to the benefit of the respondent, and the respondent did not refuse to accept such benefit, and in this respect provisions of section 70 of the Contract Act definitely applies to prevent the respondent from enriching themselves by such work. Lord, where is the arbitrator, I ask myself, clothed with the power to invoke section 70? There is no such power. I'll show judgments. He cannot invoke 70. Party also here, my lord, your lordship, I have shown the submission that he has argued this, but from the statement of claim, my lord, there is no whisper of, my lord, any principle of unjust enrichment. No case like this also made out in the pleadings. Kindly takes, my lord, same page, last line, last few lines, which starts with, these are allegations. These are allegations for allegation's sake, which have no legs to stand on. On the point raised by the learned advocate for the respondent that the claimant executed the work at the original tender rate till completion, and the claimant's claims are false and imaginary, it was an impractical and totally an unwholesome suggestion that the contractor has to work at the original contract rate even after expiration of the stipulated period and would not claim any higher rate, on the point that the contract was automatically revalidated when the claimant executed the work after the expiry of the stipulated period, is also an impractical argument propounded by the learned advocate for the respondent when the original contract was I don't know what this means, was non-est, because the contract cannot be revalidated without the concurrence of the governor. These are hollow and lame excuses. So, my lord, the arbitrator acts as ex debito justitiae, and my lord, he is of course not a court, my lord. He is an arbitrator who is formed, my lord, gets his power from the contract. He cannot, my lord, act ex debito justitiae. Also judgment on that also, and do this, my lord, public policy and other equitable relief. He cannot grant that. Now, my lord, even though he says contract had expired, there was no contract, the terms became ocious, kindly see, my lord, what he ultimately grants. That is, next page, page 96, internal page 91.
Yes.
Just before that, he has seen the judgments relied upon by my learned friend under section 73, and then at 91 he says, after carefully considering the interview 91 facts and the argument of the learned advocate of the parties, I unhesitatingly hold that the respondent had miserably failed to perform their reciprocal obligation and had breached the contract and made themselves liable to compensate for the said breaches, not only done during the contractual period, but also during the overrun period, and enrich themselves by the work executed by the claimant beyond the stipulated period. There is absolutely, my lord, no parity with what he says in his reasoning. and what he ultimately holds. He says there is no contract. I am invoking section 70. I'll show, my lord, section 70 can only be applicable when there is no contractual
No,
relationship.
but in this paragraph, carefully considering the facts, the contractual obligation breached the contract and made themselves liable for compensate the claimant for the said breaches not only during the contractual period but also overrun. So, as per this, during the contractual period also there was a breach.
There was breach. He says there is a breach. Where is, my lord? I say they're finding that there is the breach. And because of that breach, he is giving the compensation. He is saying that beyond 99, there is no contract. And the claims that were granted, my lord, I'll show, is all beyond 99. And this is, my lord, on the principle of section 73. My lord, kindly just takes the previous page. What the judgments that were cited also is the middle. Next, it appears that the learned advocate for the claimant cited certain authorities on the apex court on the point loss of profit sustained by the claimant. He relied on the case of such and such. This case was based on section 73. So, my lord, he is judgments on section 73, which is applicable where during the contractual period, if a party breaches, my lord, section 73, your lordship knows, my lord, compensation can be granted. But there is no discussion that there was any breach of the contract. He says that I have not given them on time. And he has, my lord, written pages on that I have not given on time. But he could have said, my lord, that if I have not given it on time, he could have somehow impliedly, my lord, included my breach within the periphery of the contract. That would sustain the contract. But by saying that the contract did not exist and the terms became ocious, not applicable, there was mutual understanding beyond the period, my lord, that is the death knell. Now, my lord, this is one point. Secondly, my lord, and I will cite some judgments on that. Secondly, my lord, the claims that are allowed, my lord, page 9, internal page 91, 92, 93, 94. He has allowed, my lord, idle charges, then, my lord, escalation charges, etc. There is not one sentence in the reasoning part which, my lord, discusses the clauses of the contract. Not one sentence. I am not even going before that page 73, because before that he has recorded the submissions. But he has not applied his mind, my lord, to any of the clauses of the contract. Because in his mind, the contract did not even exist. And he was, my lord, doing an equitable justice to the parties.
Yes.
Then, number 3. These figures, my lord, that have been allowed, kindly takes page 97. Let's take one example, my lord. Claim number 3. Claim for loss suffered for idle charges of labor, etc., which is set out in pages 44 and 45. This is what is there. And on the right hand side, he allows 20%. Look, there has to be some formula on the basis of which he is giving 20%, Hudson formula and whatever, my lord, building contracts formula is there. I will show, my lord, the Supreme Court has said that you cannot grant like ad hoc like this. You have to say why you are granting this. And especially in teeth of an argument that there is a clause in the contract which does not allow idle charges, there must be some discussion. There is no discussion.
That you already argued on the last occasion.
So I have said, my lord, that we have said contract does not provide this. Therefore, it could not have been. But today I am saying, my lord, whether or not, my lord, it is, let's say, my lord, if they are saying, or there are judgments which say, yes, this can be allowed. If there is no escalation clause, arbitrator is closed. The arbitrator must see that and hold that.
Okay.
If there is non-application of,
That's why you argued that there is no reasoning has been given with regard to the awarding this
yes,
amount
yes,
in paragraph 92 and 91 and 92.
no reasoning given.
reasoning.
Yes, but I don't know if that Bharat Koki and all, Milord, there is one Supreme Court judgment 2006 which says, Milord, that if the clauses of the contract which the arbitrator is interpreting, Milord, whether to allow this or not to allow this, if this is not in the reasoning part, that allowed, Milord, award cannot be sustained. So my learned friend has relied on a judgment of Justice Banerjee, which says, Milord, escalation clause, if you have gone beyond the period and done, if there was a price hike, it can be allowed, Milord. Yes, I'm saying that in certain cases it can be allowed. But in this case, the arbitrator must decide that it should be allowed or it should not be allowed by referring to these clauses. He has not done that exercise, which is not a judicious approach. That, Milord, I had shown associate builders. Now, Milord, on this, Milord, on this, I will not elaborate now. Milord, I'll just show that section 70, Milord, is applicable only when there is no contract. That is, at the copy could the other side. 2019 volume 5 SCC 341. 5 SCC 341 Mahanagar Telephone Nigam Limited. বলছি Lord, kindly takes paragraph 4, 5, 6 and 8. Yes. This, Milord, I will not, Milord, show the contract act because it's set out here. Having heard the learned counsel for both sides, one neat question arises before this court, which is whether when parties are governed by contract, a claim in quantum merit under section 70 of the Contract Act would be permissible. Section 70 of the Contract Act reads as under, and Milord, this is set out, where a person lawfully does anything for a person or delivers anything, not intending to do so gratuitously, and such other person enjoys the benefit.
That is the law.
Yes. This section is in chapter 5 of the Contract Act, which chapter is headed of certain relations resembling those created by contract. There are 5 sections that are contained in this chapter. Each of them is posited on the fact that there is in fact no contractual relationship between the parties claiming under this chapter. For example, 68, if a person is incapable of entering into a contract, is supplied necessaries. Then, Milord, 69 he has referred to. Then section 70. And lastly, he says, it is in this setting that section 70 occurs. So, only from section 68 to 70, if there is no contract, these principles, Milord, will apply. Then, Milord, paragraph 5, Milord, and old, Milord, English judgment is referred to, Moselle and Solomon, on this principle. Then, Milord, kindly takes para 7. In Alopi Prasad and Sons, this is, Milord, factually very similar to our case. I will show this. This court dealt with an arbitration award which inter alia awarded certain amount on the basis of quantum merit. In setting aside the award on the grounds of error apparent on the face of the record, this court held he, which is, Milord, a short form, having been supplied by the agents. Sorry, ghee money is ghee. The ghee was supplied in this case. Supplied by the agents under the terms of the contract. The right of the agents was to receive remuneration under the terms of that contract. It is difficult to appreciate the argument advanced by Mr. Chatterjee that the agents were entitled to claim remuneration at rates substantially different from the terms stipulated on the basis of quantum merit. Compensation quantum merit is awarded for work done or services rendered when the price thereof is not fixed by a contract. For work done or services rendered pursuant to a terms of the contract, compensation quantum merit cannot be awarded where the contract provides for consideration payable in that behalf. Quantum merit is but reasonable compensation awarded on implication of a contract to remunerate and an express stipulation governing the relation between the parties under the contract cannot be displaced by assuming that the stipulation is not reasonable. Then, Milord, para 8. I am not, Milord, I para 8, Milord, some portion I will show. It was an earlier judgment also. Mulam Chand versus State. Kindly takes para 8, Milord, last few paragraphs on the same, last few lines, which starts with the word, the important point.
Yes.
The important point to notice is that in a case falling under section 70, the person doing something for another or delivering something or another to another cannot sue for specific performance of the contract nor ask for damages for breach of contract. Milord, this is very important because what he has ultimately allowed is damages for breach of contract. So you cannot allow damages for breach of contract if you are saying that there was no contract under section 70. Nor damages for breach of contract for the simple reason that there is no contract between him and the other person for whom he does something or to whom he delivers something. So where a claim for compensation is made by one person against another under section 70, it is not on the basis of any subsisting contract between the parties, but on a different kind of obligation. The juristic basis of the obligation in such a case is not founded upon any contract or tort, but a third category, which is quasi-contract or. And then, Milord, next paragraph is about section 73. So in this case, Milord, compensation, there was breach. If there is breach, compensation can be given under section 73, which is paragraph 9. Compensation for loss of damage caused by breach of contract. So when the arbitrator has himself said there is no contract between the parties, how can Milord then he in the end say that there was breach and I am giving you compensation?
Yes.
Now, Milord, kindly takes on this point just two more two more. This Alopi Prasad, Milord, which was quoted Milord in Mahanagar. This is AIR 1960 Supreme Court 588. And that time, Milord, the law was error apparent. 1960 Supreme Court 588.
Yeah.
Yes. Paragraphs, Milord, 588. Paragraphs, Milord, 19 to 24.
Yes.
Facts are, Milord, very similar here. Here, Milord, World War II broke out during the contract. And then, Milord, the party said the contract was frustrated. I am entitled to damages because price escalation happened, etc. etc. The court said, Milord, that no, because there was extension, you have performed the contract, you cannot plead that the contract was frustrated. You have performed it. And once you have performed it, you will have to be bound by the terms of the contract. So price escalation and all the other, Milord, enhanced price was not allowed. Kindly takes, Milord. And the principle of quantum merit also, Milord, was said to be wrong. To be applied by para 19. The original agreement dated May 3, 1937 was modified by the supplementary agreement dated 20th June 1942, and the arbitrators have held that the modified agreement was binding upon the agents. By the agreement as modified, a graded scale was fixed for the establishment and the contingencies to be paid to the agents, and also for the mandi charges and overhead expenses. The arbitrators still proceeded to award an additional amount for establishment and contingencies and an additional amount for mandi charges. By clause 14A read with clause 12B2 of the agreement, the rate at which establishment and contingency charges were to be paid was expressly stipulated, and there is no dispute that the government have paid to the agents those charges at the stipulated rate for ghee actually purchased. The award of the arbitrator show that the amount actually received from the government total to such and such, whereas according to the accounts maintained by the agents, they had spent such and such. Granting that agents had incurred this additional expenditure under the head establishment and contingencies, when the contract expressly stipulated for payment of charges at rates specified therein, we fail to appreciate on what ground the arbitrators could ignore the express covenants between the parties and award to the agents amounts which the Union of India had not agreed to pay to the agents. The award of the arbitrators awarding additional expenses under the head of establishment and contingencies together with interest is on the face of it erroneous. Then Millot kindly takes paragraph 20, Millot. He says that there was mutual. I'll read 20. Before the arbitrators, a number of Arhachiyas who supplied ghee to the agents appeared and produced extracts from their books showing the amounts actually due to them from the latter. Detailed charts were shown. Arbitrators were satisfied that the statements produced reflected a general rise in prices and cost of labor. Taking into consideration the fact that the other persons were buying ghee at rates considerably in excess of the stipulated rates, arbitrators held that the agents were entitled to be reimbursed to the extent of rupees 11 lakhs, but the terms of the contract stipulating the rate at which financing and overhead charges were to be paid under clause 13A read with 12B remained binding so long as the contract was not abandoned or altered or by mutual agreement, and the arbitrators had no authority to award any compensation in excess of the amount expressly stipulated to be paid. Mr. Chatterjee, on behalf of the agent, submitted that the circumstances existing at the time when the terms of the contract were settled were entirely displaced by the reason of the commencement of the hostilities in the Second World War, and the terms of the contract agreed upon in the light of the circumstances existing in May could not, in view of the turn of events which were never in the contemplation of the parties, remain binding upon the agents. This argument is untrue in fact and unsupportable in law. The contract was modified on 20th June 1942. Here also, Millard, extensions were given by mutual consent, and the modification was made nearly 3 years after the commencement of the hostilities. The agents were fully aware of the altered circumstances at the date when the modified schedule for payment of overhead charges, contingencies, and buying remuneration was agreed. Again, a contract is not frustrated merely because the circumstances in which the contract was made are altered. Then, Miller, I'm not showing section 56. Performance of the contract had not become impossible or unlawful. The contract was in fact performed by the agents and they have received remuneration expressly stipulated to be paid therein. Indian Contract Act does not enable a party to contract to ignore the express covenants thereof and to claim payment of consideration for performance of the contract at rates different from the stipulated rates on some vague plea of equity. Miller kindly notes this. The parties to an executory contract are often faced in the course of carrying it out with a turn of events which they did not at all anticipate, a wholly abnormal rise or fall in prices, a sudden depreciation of currency, an unexpected obstacle to execution, or the like. Yet it does not in itself affect the bargain that they have made. If, on the other hand, a consideration of the terms of the contract in the light of the circumstances existing when it was made shows that they have never agreed to be bound in a fundamentally different situation which has now unexpectedly emerged, the contract ceases to bind at that point, not because the court in its discretion thinks it's just and reasonable to qualify the terms of the contract, but because on its true consideration, it does not apply in that situation. Now, Millard, para 22. So here also they say that railway has not given me, prices have increased. Millard, all these contingencies, Millard, they had considered. After that, they had entered. And the extensions were also, Millard, granted much later. They could have said, I don't want to proceed anymore, you ended. They did not do that. Millard, para 20.
What will happen the work which he executed subsequently? What will happen to that?
The work which he has substituted. If the arbitrator, Millard, had held that that work which he had done was, Millard, an extension of the contract which expired in 99, then, Millard, perhaps the award would be today, Millard, your lordship is not in appeal. What will happen to them, not happen to them, Millard, is not the question, consideration. Question.
Then again the court will go to the equity.
Yes, that is also, Millard, beyond the scope of 34.
Okay.
So today, here your lordship has to see what the arbitrator has done is correct or not. That's all.
So that's what the
Consequences, Millard, I mean, we all have consequences for the choices we make, Millard. And this is one of the choices that they made to go before the arbitrator, not take this point, my lord, in the statement of claim. The arbitrator, my lord, has passed an award, and my lord, they have taken the money. Today they can't go. I'm sure relief will.
For the gander is food for the goose. None of this is in the petition. So they have taken the choice of not pleading all these points in the petition. It has consequences.
So, my lord, I have to really elaborate to your lordship what is perverse and patent illegality.
I need to show you can't say it's perverse. Then that would have been easiest draft to
And
section 34.
my lord, section, this is a section 34 court. Your lordship is not in appeal over the arbitrator. Your lordship has to see whether there is error apparent, whether it is.
That's why you started from the associate builder.
Yes. And every day, my lord, I'll quickly finish. If not today, next day, I'll remind that this is because that equitable consideration will come. Any human being, it will come. That what will happen to a contractor who has done the work and beyond the stipulated period, and my lord has engaged idle machinery, labor, etc. What a good, bad, indifferent, my lord, this will come.
Okay.
But we have to be within the
Okay,
periphery of
Continue.
the law.
Continue.
My lord, paragraph 22. There is no general liberty reserved to the courts to absolve a party from liability to perform his part of the contract merely because on account of an uncontemplated turn of events.
The conclusion is 23. Come to the
And 24. We are unable to agree with the contention that yes, ignoring the express terms of the contract. And 24, relying 24, my lord, he talks about quantum merit. 24. Relying on 222 of the contractors by which duty to indemnify the agent occurs is imposed upon the employer. Arbitrators could not award compensation to the agents in excess of expressly stipulated consideration. The claim made by the agents was not for indemnity for consequences of acts lawfully done by them on behalf of the government. It was a claim for charges incurred by them in excess of those stipulated. Such a claim was not a claim for indemnity, but a claim for enhancement. Assuming the agents relied on the assurances alleged to be given by the director in charge of purchases in the absence of an express covenant modifying the contract which governed the relation of the agents with the government of India, vague assurances could not modify the contract. He having been supplied by the agents under the terms of the contract, the right of the agents was to receive remuneration under the terms of that contract.
This is the correct.
Yes, it is difficult to appreciate the argument advanced by Mr. Chatterjee that the agents were entitled to claim remuneration at rates substantially different from the terms stipulated on the basis of quantum merit. Compensation quantum merit is awarded for work done on services when the price thereof is not fixed by a contract. For work done on services rendered pursuant to terms of contract, compensation cannot be awarded where the contract provides. So, if he has said it's void, it cannot. And also, my lord will note, the arbitrator himself says, contract expired, should have been done with the governor.
No, that is correct.
There was mutual understanding. So there is a civil forum for that. Arbitration is not the forum. What fell from your lordship?
Damages.
What will happen, my lord, to this excess work? Civil suit. But arbitrator derives his power from the contract. He can't grant this.
Got it.
Now, my lord, this
how much time you will take further?
My lord, today, my lord, let me finish this section 70.1 more.
1 p.m. I think 1 p.m. matter is there.
Oh, ache.
1 p.m. matter.
And then matter fixed at 1. My lord, then Anand.
When can be fixed? This is a commercial, no? It's not commercial. Why it is not commercial, Mr. Mitra? Why it is non-commercial?
It was filed initially, it is not converted.
Section
It was not converted.
Section
It
15.
should be converted.
All arbitration.
The state will take another 1 year to convert it. I cannot convert. No, state will 1 year.
This is a state.
Yes.
Oh, okay, sorry. Yes. So I will dismiss hearing now. It is not the jurisdiction. Simple.
Yeah, but then your lordship has converted other matters.
The state will have to convert it, not me.
I thought it is commercial.
It should have been.
Should have been.
My lord, it should have.
When you filed? 2008.
2008.
Was a
So, my lord,
old regime.
If I pass also award, then you will say Without a jurisdiction, the court has passed.
No, Lordship will change. That depends.
What can be done?
That is.
My lord, your lordship transfer to the commercial division. That 2015 it came. Other suits, your lordship is still doing it, giving us the indulgence.
Sensations appearing for
His
the
number
plaintiff.
very good,
Sensations
actually.
appearing for. Now I have to read first what is whether it's the
Commercial and non-commercial.
sensations
The
appearing for
department
the
will give a number, I believe.
sensations appearing for the
So only a number will change in
defendant
commercial.
cost title.
Oh,
Defendant respondent. Full stop. The counsel for the respondent, counsel for the petitioner argued at length by giving reply to the submission made by the counsel for the respondent. But during the argument, this court find that the dispute between the
My lord, there is
parties.
I am told, I'm sorry, my lord, that a new practice direction has come where the department is to be directed, my lord, for the.
That's right.
Yes.
Department will do, but with regard to the re-verification, reaffirmation, but this is the arbitration. The statement of truth will not also there, but you have to take. You have to file the state. You have to file the.
Arbitration perhaps
not
not.
in arbitration. I don't know.
It is the arbitration only. It will be amended. In the department will do the amended and the matter will be
Post it
listed.
in the commercial division.
Find that the dispute between the parties is commercial in nature, but this arbitration proceeding is filed. This application under section 34 of the arbitration is filed in the year 2008, and at the relevant point of time, the provisions of the commercial code was not promulgated. Accordingly, the parties to the suit, parties to the matter, submit that the AP number 579 of 2008 be transferred from this court to commercial division. Consider the submission made by the counsel for the respective parties, peruse the pleadings. This court find that the application is required to be transferred from this court to commercial division. Accordingly, AP number 579 of 2008 is transferred from this court to commercial division. The department is directed to take to amend the cost title by incorporating the commercial code and to list the matter before this court on 29th February.
Well, your lordship will again fix a time as today. my lord.
Commercial, there is no time limit. You come at 10:30 with your brief. The court will
Yes.
start.
Now, the non-commercial matter is part heard before your lordship. That will remain.
That will remain.
That will remain. Oblige.
Because the
Number will remain the same.
only number will change. Only the commercial division.
Commercial division will add it.
Number will not change.
29
Now
February.
then commercial division, it will be taken up and quickly happen.
So 29th February,
29 February.
leap year.
Leave here.
Leap year. They got an extra day or to work. No, commercial time. Oh, put the gate. Oh, here. Oblige.
Obliged.
For the plaintiff, my lord, the plaintiff was being cross-examined. He is the propounder.
This is non-commercial, my lord.
Now the exclusively commercial division is required.
Yes, my lord. May I proceed, my lord?
Gautam Chatterjee.
No?
Substantial cross-examination is completed, my lord. Today, learned friend was supposed to complete the cross-examination.
No, I wasn't about to
Shinugupta
complete,
was
but I will
appearing.
proceed, my lord.
Let us see.
Would you be able to contradict me if I said that Meera Chatterjee used to occupy managerial position in WB SEDCL?
Yes.
Now, would you be able to contradict me? Or answer a no hobe tahole. Would you also agree if I said that Meera Chatterjee knew how to read and write in English? And would you also agree if I said that Meera Chatterjee would often issue correspondence and letters in English?
মীরা চ্যাটার্জি অফিসে কি ইংরেজি লিখতেন না কি লিখতেন সেটা তো আমি বলতে পারবো না।
I do not know whether Meera Chatterjee write correspondence in English or not.
Question repeated. একবার কোয়েশ্চেনটা পড়ে দিন একবার। Often issue correspondence and letters in English. I did not say in office or not.
লিখতেন, নিশ্চয়ই লিখতেন।
Yeah. Not working.
Then what is your explanation with regard to the alleged will being drafted in Bengali?
এটা আমার মা করেছিলেন, আমার মাই বলতে পারবে।
That my mother had that my mother can
My mother can only say,
Can you produce any deed, documents which was executed by late Meera Chatterjee, which was drafted in Bengali?
দেখতে হবে।
I have to see.
I suggested to you that drafting and preparation of the alleged will was done at your instance and upon your instruction. What do you say?
আই কমপ্লিটলি ডিসএগ্রি। এটা মার ইনস্ট্রাকশনেই উইলটা তৈরি করেছিলেন অ্যাডভোকেট অমিতাভ রায়।
this will was drafted in my mother's will instructed by
বাই অ্যাডভোকেট অমিতাভ রায়।
Where is the chamber of this Mr. Amitabh Roy?
রুম নাম্বার 1, বার লাইব্রেরি, আলিপুর জাজেস পুলিশ কোর্ট, ক্যালকাটা 727।
বলছে বলুন।
আলিপুর জাজ, আলিপুর রুম নাম্বার 1, বার লাইব্রেরি, জাজেস পুলিশ কোর্ট, আলিপুর, ক্যালকাটা 27।
How many times have you visited this chamber?
Once.
And what was the date on which you had visited?
1st July 2013.
If you had not visited the chamber of Mr. Amitabh Roy before July 1, 2013, how were you able to give directions to his chamber to the other attesting witnesses of the alleged will?
আমার মা আমাকে 29th জুন
my mother on 29th
2013-তে ডেকে বলেছিলেন সবাইকে,
called me and told me in
2013 হ্যাঁ হ্যাঁ 29th জুন 2013 আমাকে ডেকে বলেছিলেন সবাইকে ওখানে অ্যাসেম্বল করে আমার গাড়িতে করে নিয়ে যেতে।
assemble everyone there and take them
রুম নাম্বার 1,
and take them
বার লাইব্রেরি, আলিপুর জাজেস পুলিশ কোর্ট, কলকাতা 27। আমাকে মা একটা পেপার অ্যাড্রেস লেখা কাগজও দিয়েছিলেন, তাতে ওই অ্যাড্রেসটা লেখা ছিল।
my mother had given a sheet of paper in which this address was
অনির্বাণ চ্যাটার্জিকে ওভার ফোন বলে দিয়েছিলেন ওইখানে চলে যেতে। অ্যাটেস্টিং উইটনেস নাম্বার 1।
had asked one and Anirban Chatterjee
ওভার ফোন
to reach the place.
হ্যাঁ, সেটাও আমাকে 29th জুন 2013-তে বলেছিলেন।
That my mother had put
13.
And how was Ranjan Matthews, the other attesting witness, informed about this alleged execution of the will?
এটাও আমার মা ওভার ফোন রঞ্জন ম্যাথিউসকে বলেছিলেন। আমাকে যখন ডেকে 29 জুন বলেন, তখন আমাকে বলেন যে রঞ্জন ম্যাথিউস এবং অনির্বাণকে আমি ওভার ফোন বলে দিয়েছি।
This also my mother had also asked Ranjan Matthew come reach the place over phone, and this also my mother told me that she had informed Ranjan Matthew and
অনির্বাণ চ্যাটার্জি
Chatterjee come to the place on 29th June.
30.
So is it your evidence that although your mother had accompanied you on July 1, 2013, based on the address mentioned in the chit of paper handed to you, you could direct the other persons towards the chamber of Mr. Amitabh Roy?
অনির্বাণ চ্যাটার্জিকে আমি কোনো রকম ডাইরেকশন দেইনি। অনির্বাণ চ্যাটার্জিকে আমার মা ওভার টেলিফোন বলেছিল।
I did not give any direction to Honorable Chatterjee. My mother,
অনির্বাণ চ্যাটার্জি
my mother had given him the
ডাইরেকশন ওভার ফোন।
over.
একবার একটু লাস্ট কোয়েশ্চেনটা করবেন। Other persons. With my lord's leave, may I just explain? Mr. Witness, I am not asking you whether you had directed Mr. Anirban Chatterjee to the chamber of Amitabh Roy. I said other persons. So that is why I am repeating the question. Question repeated. দরকার হলে আরেকবার পড়ে দিন একটু জোরে।
রঞ্জন ম্যাথিউস 11টা নাগাদ আমাদের বাড়িতে আসেন। তারপর আমরা সবাই আমার গাড়িতে করে আমার মা, আমার ওয়াইফ এবং আমার বোন আলিপুর পুলিশ কোর্টে রিচ করি।
Ranjan Matthew came to our house at
11 around 11 yes sir.
a.m. Then I along with my mother and my wife
My sister
and my sister went to the place on a car.
হ্যাঁ গাড়ি আমার গাড়ি।
My car.
There are a lot of chambers in Alipur Police Court complex. I am asking you, how were you able to direct the other persons to the chamber of Amitabh Roy if you had not visited his chamber before, as you had just deposed? Question mark.
আমি যে কাগজটা বা আমাকে দিয়েছিলেন সেই কাগজটা একজনকে দেখাতেই দেখি আমাকে বা ওই বাড়িটা দেখিয়ে দিলেন।
The sheet of paper that my mother had handed over to me, I put the sheet of paper person in that place and directly.
I suggested to you that it was you who had directed Meera Chatterjee, Ranjan Matthews, and Anirban Chatterjee to visit the chamber of Amitabh Roy. Full stop. What do you say? Question mark.
Completely disagree. অনির্বাণ চ্যাটার্জি কে আমার মাই বলেছিলেন ওভার ফোন, আলিপুর পুলিশ কোর্টের এই অ্যাড্রেসটা দিয়ে দিয়েছিলেন ওভার ফোন। অনির্বাণ চ্যাটার্জি সেই অনুযায়ী ওখানে এসেছিলেন। বাদ বাকিদের আমি ড্রাইভ করে নিয়ে গেছিলাম, সেটাও আমার মা আমাকে পিস অফ পেপার দিয়েছিল অ্যাড্রেসের।
My mother had asked Honorable Chatterjee
for phone
for phone
and given him the address.
and had given the address of, and I had taken other persons the place. And my
Mother has given me the sheet of paper.
To the place in my car at the address which my mother has given in a sheet of paper.
Would you be able to contradict me if I say that Ranjan Matthews has deposed that it was you who had directed him to the chamber of Mr. Amitabh Roy?
Obviously, আমি তো কারের ড্রাইভার ছিলাম, আমরাই তো সবাই একসঙ্গেই তো ছিলাম, সবাই অ্যাড্রেসে একসঙ্গেই তো নিয়ে গেছিলাম।
I was the
Driver.
driver of the vehicle.
আর অ্যাড্রেসটা আমার হাতেই ছিল।
And I had the address of the vehicle.
Yes.
And I had taken everyone on my car to the place.
Since how long have you known Mr. Anirban Chatterjee?
অনির্বাণ চ্যাটার্জি আমাদের অ্যাকচুয়ালি ফ্যামিলি ফ্রেন্ড, আমাদের বাড়ির খুব কাছাকাছি ওর বাড়ি, ও আমাদের বাড়িতে প্রায়ই আসতো।
Anirban Chatterjee is our family friend, and his house is near our house. And openly,
আমার মা ওকে খুব পছন্দ করতেন, নিজের ছেলের মতোই কনসিডার করতেন।
my mother is treat him and like him like her own son.
আমার মাই ইন্ডিপেন্ডেন্ট ডিসিশন নিয়ে ওকে ওভার ফোন রিকোয়েস্ট করেছিল এই উইলে উইটনেস থাকবার জন্য।
My mother independently had decided to keep Anirban Chatterjee and the witness in the dead.
অনির্বাণ চ্যাটার্জি অলসো আমার অফিস কলিগ, এক্স অফিস কলিগ অ্যান্ড ফ্রেন্ড।
কোশ্চেনটা কি ছিল? Question repeated.
From 1995.
When you say that Anirban Chatterjee was your office colleague, can you name can you say from which year Anirban Chatterjee and you had become office colleagues?
From 1995.
My lord, wholly irrelevant questions, my lord. Well, the answer
Anirban Chatterjee is an attesting witness.
The
he
probate,
answered with respect to Anirban Chatterjee.
maybe the probate case.
And he has already answered.
This
My
is
lord,
only this is only with regard to testing of the attesting witness.
yes, my lord, these questions were over on the earlier question.
That
my lord.
time I will see.
Similar questions, man.
আরেকটা জিনিস প্লিজ, অনির্বাণ চ্যাটার্জিকে আমার মা প্রত্যেকটা
Witness volunteers.
অনির্বাণ চ্যাটার্জিকে আমার মা প্রত্যেকটা ফাংশনে আমাদের বাড়িতে ইনভাইট করত।
My mother used to invite Anirban Chatterjee in our house in every
Functions. Yes. Next.
I suggested to you that Anirban Chatterjee was your friend and acquaintance and not a family friend. What do you say?
Completely disagree. He is my friend and also my family friend.
Would you be able to contradict me if I say that the residential house at 11 by 5 capital A, Netaji Nagar, was a 3-storied building?
Yes.
Would you also agree that this building was constructed upon the land after it was purchased by your mother?
Yes.
Would you also agree that না just a question টা কেটে দিন would you be able to contradict me if I say that these three stories were constructed for each of the three children of late Meera Chatterjee?
I completely disagree because আমার মা 2003 সালে আমার ভাইয়ের বিয়ে হয় 2002 সালে। তো 2003 সালে এরপর ভাইয়ের সঙ্গে ভাইয়ের ওয়াইফের সঙ্গে মার অল্টারকেশন হতো, হট এক্সচেঞ্জ হতো, যার ফলে
My brother got married.
2002, হ্যাঁ 2002 এর বিয়ের পরে
When my brother married,
হ্যাঁ
my mother had altercations with my brother and
মাই ব্রাদার্স ওয়াইফ
my brother's wife
রেগুলার বেসিস।
on a regular basis.
সেই জন্য আমার আমার মা 2003 সালের আগস্ট ফার্স্ট উইকে ওদের বাড়ি থেকে চলে যেতে পারে।
In August, in the month of the first week of August, my mother asked them to leave the house.
আমাদের বাড়ি তখন ছিল গ্রাউন্ড ফ্লোর অ্যান্ড ফার্স্ট ফ্লোর।
Our house at that time was ground floor.
অ্যান্ড 2005-06 আমার মা লেবার কন্ট্রাক্টরকে দিয়ে আমাদের সেকেন্ড ফ্লোর তৈরি করেন।
My mother constructed
Constructed second floor with the help of the labor contractor.
and the help of the labor contractor.
Is there any letter or email or message or any other document which could substantiate that your mother had asked Partho Chatterjee to leave the house in 2003? August, 2003?
চিঠি, এটার কোনো চিঠি হয়? মা যদি বলে মা যদি বলে কাউকে বাড়ি ছাড়তে মার সঙ্গে অল্টারকেশনের পর, তাতে কি কোনো মা কি কখনো চিঠি দিয়ে ছেলেকে বলে যে তুমি বাড়ি থেকে চলে যাও? ইজ ইট পসিবল?
possible that
My lord, a question cannot be answered by a question. First, let him answer yes or no and then justify.
What is your
No,
question?
no.
My
No,
lord,
sir.
my lord,
Okay, no. That
No,
next.
no. Is it your evidence that because Meera Chatterjee asked Partho Chatterjee to leave the house, that is why late Meera Chatterjee did not make any provision in the will with respect to the house in favor of Partho Chatterjee?
আমার মা উইলে
আনসারটা কোয়েশ্চেনটা একবার একটু শুনে নিন।
I have heard this question clearly. I have heard. আমার মা মীরা চ্যাটার্জি 1 জুলাই 2013-তে উইল এক্সিকিউট করেন আলিপুরে।
my mother, Meera Chatterjee, executed on 1st July 2013 at Alipur.
হ্যাঁ 1 জুলাই 2013 আলিপুর কোর্ট। সেই উইলে
That
পরিষ্কার লেখা আছে যে
clearly written that
বাড়ি কিভাবে সেগ্রিগেশন হবে,
how written that how the house
আর আমার ভাইকে 15 লাখ টাকা দিতে আমাকে নির্দেশ দিয়েছিলেন।
and the will my mother had directed to pay that
Brother.
So you mean to say that the alleged incident of August 2003 has got nothing to do with the construction of the will?
উইলের কনস্ট্রাকশনের সঙ্গে কোনো সম্পর্ক নেই। হ্যাঁ এটা তো আমার মা বলতে পারবেন।
That my mother can say.
Do you know how many children Partho Chatterjee has?
একটা মেয়ে, ঐশী চ্যাটার্জি।
And do you know when she was born?
6th March 2004.
So is it your evidence that late Meera Chatterjee asked Partho Chatterjee and his pregnant wife to leave the house in August 2003?
Yes, my lord. যার ফলে আমার ভাই পার্থ চ্যাটার্জি আমার বোন কেয়া রয়কে রিকোয়েস্ট করে ওর ওয়াইফকে এবং অ্যালং উইথ হিম, মানে আমার ভাই 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 9/89 নেতাজি নগর, কলকাতা 92-তে থাকবে বলে। এবং
To which my brother had requested my sister K.R. Roy accommodate him and his
Pregnant, yes.
pregnant wife at 9 by
9/89 নেতাজি নগর, কলকাতা 92-তে। এবং আমার বোন কেয়া রয় ওদের পুরো টেক কেয়ার করে এবং আফটার মানে বিফোর বার্থ অ্যান্ড আফটার বার্থ।
them as well as the child before and after the birth.
I suggest it to you that Partho Chatterjee and his pregnant wife was forced to leave the house owing to the disturbances created by you and your wife. What do you say?
পার্থ চ্যাটার্জি আমাদের হাউস থেকে চলে গেছিল আবার 2003 সালের আগস্ট মাসে।
Pastor Chatterjee,
First, you hear the question.
আচ্ছা, ও
It is a question
no,
that
I completely disagree.
Lord, may I come back on another day?
why?
I'll
How
continue.
many-
Well, I can continue, but I will not be able to conclude.
How
my-
much time?
My lord, any day, my lord gives me half an hour to 45 minutes.
On the
I'll
last
conclude.
occasion also you did half an hour. That's why today it was fixed on one
No, my lord,
year.
on the last occasion it was fixed, but that matter could not be taken up because there was a resolution. So thereafter the matter got called, and
How
that's when
this-
my lord records that
this
I'll
way-
finish it on the next occasion. Kindly grants me half an hour to 45.
But every day, my lord, they are seeking this time, my lord.
Huh?
And every
My
day.
lord,
Can
rec-
be done.
My
When
lord-
the matter is fixed, your bar is taking the resolutions.
No, no, my lord, I'm not
So,
on the resolution, my lord.
then
The cross-exam, length of the
Cross-examination court cannot stop also.
my lord records, I'll finish it on the next day.
questions
Half-
I cannot stop you finish it, but it
No,
is
no,
not-
no. I that's my voluntary. I am voluntarily undertaking. I'll finish it. Kindly gives me half an hour to 45 minutes and any day, my lord. My lord may record that. That's my that I'm volunteering to.
Yes, I think fourth time the witness is coming.
My lord, chief was also done for 4 occasions, my lord. Usually cross-examination is.
Like this, the witness will examine how the case can be disposed of. The matter is fixed today for further cross-examination of the plaintiff witness number 1.
My lord, two.
Plaintiff witness number 2. Full stop. Cross-examination resumed today, but due to paucity of time, cross-examination could not be completed. Give the date. What time? 1st April at 12 noon.
I'm grateful, my lord. I'll conclude on that day.
My lord, nothing. My lord, in March, my lord, if so commences, my lord.
Then I will give to about 3:45, 1. This
My
is
lord,
the,
I want.
that's the problem. That's why I'm telling. If once you start, you should finish it. Every day, this is the 5th time.
And
the
I'll finish on the
witness-
next occasion. I assure my lord.
He's interested, he's coming. Otherwise, other witness will not come to the court.
If a shorter time can fix, if it's so,
Shorter time, there is no shorter time. Then it will be 3:45. It is a
sound
risky.
like this.
I don't want to take a chance.
It is a
because-
risk. Then you will not get the April also. Then you will have to go for the May.
I assure my learned friend I'll conclude on the next.
Or otherwise, I will fix 2 dates. And after conclusion, your the other witness is there.
No, my lord.
Then I'll produce my witness.
Okay, come on first. Then you will produce the witness on the next day.
Kindly allow me to conclude and thereafter.
No problem. Here is the what the procedure is adopted on the same day, neither a cross-examination, neither examination in chief. That's why they think delay. Otherwise, I will fix the day-to-day hearing.
Malat fixes up, Malat will take the chance, Malat. If
What? Then you will say, no, you're not good. Then the whole list will
that's
be.
the problem, Malat.
Okay,
My
come
lord
on.
fixes it on any day, kindly gives me half an hour to 45 minutes, any day, my lord. Before 1st of April also, I don't have a problem. If it is possible.
नहीं है, कोई डेट नहीं है. 3:45 कब है? This all probate matters. 13 March. What is the day?
It's Wednesday, my lord.
13 March at 3:45.
My lord. Grateful to my lord.
Okay.
I'll have to then take your lordship through the agreement. Now, kindly comes to the agreement. They have
Page
annexed it.
31
Page
of
31,
my
my lord.
application. Yes. 37. What is the total amount?
Kindly come to page 31. It begins from there. Kindly comes to page 34 first.
34, 1.1.
Yes, the last paragraph.
Last
Whereas,
1.1.
yes, no, my lord, kindly cease.
Then
And whereas the purchaser has approached the vendor to purchase the said premises more fully described in schedule below, and the vendor has agreed to sell the said premises as an absolute estate in fee simple or an estate equivalent thereof, subject to a good marketable title being made out, and the said premises is free from all encumbrances attached, and save others save claims save and accept aforesaid collateral security and mortgage with the State Bank of India at the price of such and such. Now, my lord, kindly comes to the next page.
no, no, I was not seeing it.
Kindly comes to the next page, my lord. Now, the second clause, that also says the amount of such and such.
22 lakhs.
Yes. Now, kindly comes, my lord, to page 37. Kindly comes to clause 8. And clause 10. The clause 8 says the rent payable by the purchaser will be payable till the date of registration of the deed of conveyance.
Correct.
So they are liable to pay rents till the execution of the deed of conveyance as per this agreement itself.
So what is the rent?
The last agreement that was entered to revise the rent
What was the last rent?
is 2 lakhs. Well, that agreement was of 2009.
2 lakhs.
Yes. Well, that we have disclosed.
2,40,000.
But there is also another aspect, my lord, that I have to take your lordship through. Lord, so far as the mortgage is concerned, Lord, the mortgage was of two folds. One, because of my petrol pump, there was a cash credit account. For that, there was a mortgage. The other mortgage was with regards to the plaintiff company. The plaintiff company had drawn loans and cash credit services from the bank in against my property's mortgage. And that both the mortgages have been cleared by me. And that is on record. The bank itself has put it on record to say that those amounts have been paid. And therefore, my lord, the amount that was paid on their behalf has to be also paid by them.
That is included in that 4 crores.
That amount includes that amount also.
Yes.
I cannot be made to pay. I have
In that case, here's out my application because
very well.
no problem. Here's out my. May I take leave?
The bank. Lord, I have no role to play. Lord, will kindly delete me from my and will release me.
Where is the application?
Lord, I have not made a formal application, but on the last occasion, he has submitted that the plaintiff had submitted that we have no claim against the bank. So
Let them make the submission then.
if you Lordship kindly record that, my lord, he has no objection. My name is either the plaintiff nor the defendant. I have been dragged into their unnecessary.
So it is good for the advocacy.
I'm doing him a favor.
Ah,
May I take your lordship?
So Mr. Pramanik should be grateful that he's part of
it is a good for the advocacy that though you have no role, then you are in the,
unnecessary.
and that too in the original side. Yes.
I'm sorry, Millard, I was stuck somewhere
No
else.
problem.
Millard, what we are actually looking at this juncture is, Millard, whether the scope of this application is limited to the extent that whether I'm entitled to an injunction, whether there is a prima facie case in my favor, whether there is a balance of convenience in my favor, Millard. As well as the other point of law, Millard, I would like to argue is that if a contract has a negative covenant, it's a settled principle of law. Lordship knows, Millard, Doherty's judgment, that's the 1890s judgment of English court, and followed in Vijaya Minerals as well, 96 Calcutta, that if there is a negative covenant in a contract, the court has no other option but to enforce that negative covenant and give sanction to the negative covenant, protecting the plaintiff from getting into further injury in financial losses and etc. Which cannot be otherwise quantified. Now today, where we stand is, Mr. Bose, while arguing, had made 2 points. I would like to reply to those 2 points, but he will have his chance, because he said certain things, with regard to the agreement. Lordship will kindly recollect when I was arguing right at the beginning, the agreement of sale is of 2008. There was a period within which they were supposed to complete the conveyance. That was extended twice. Now, today I put this question to myself. An agreement of 2008 subsequently extended twice. I take it 2009. They should have done it. They did not do it. Consideration with regard to the mortgage amount that has been paid, that is also admitted. Bank here is saying that they have no claims. There's a DRT order. There's a division bench order. All these things are there. Now, what I fail to understand, what Mr. Bose is trying to canvas before the bench is, say today, I have an agreement which stipulates a particular time. Time is being the essence of a contract, They should have the readiness and willingness. Lordship knows 56 Supreme Court is very clear on this. Readiness and willingness has to be reciprocal. So admittedly, there was no reciprocal obligation. So far as it comes to the first defendant case, we were always ready. We were giving them letters saying, please complete the conveyance. We had extended upon their request. Now, today, in 2024, tabulous statement is handed over and saying that you are still a tenant. I was, and I do not disagree. I was till the time it was supposed to get registered. Now, if on the failure of the part of the first defendant to register and convey the property to me, but I will be now today, it's like I lose the cake and the cherry, both. I don't have the property, and now they are saying that you can keep the cream with you. That's of no use. That will put on cholesterol. So, these are the 3 points of law I would like to argue, I'm having an extremely bad cold since 14th of January. I'm suffering. I do not know when this will go. Weather. I had stated the 3 points of law, I would like to argue. The first judgment,
on facts, you have already argued.
Yes, I have. I need not, I need not. Yeah. Only, just Lordship will kindly take page 27 once, just to a cursory view of the prayers, once, First is an order of injunction restraining the defendants, with regard to disposing of and or alienating and encumbering, creating third party, The second prayer is restraining the defendants, from disturbing peaceful possession, Third is, to deposit the original title deeds, that which the bank admittedly has given to the first defendant, We do not have the custody of it, because we paid it and the bank have released it, and that is recorded by a order of the DRT, And once more, will kindly take page 34, of the contract, the last paragraph, last 2 lines, Mortgage with the State Bank of India at or for a price of rupees 1 crore 10 lakhs, And next page is the division, We'll see handwritten 22 lakhs and then 88 lakhs only. This will be how it will be paid and adjusted. So the affirmative covenant, starts at page 3, paragraph 3, And the negative covenant, my lord, at page 36 is 6, Roman 6. And there's another negative covenant, my lord, which is at Roman 11. He will not induct any tenant, my lord. So today, my lord, I am on a very limited scope of this application is whether I am entitled to an injunction. If so, when and how I am entitled to. Secondly is with regard to when an injunction can be granted in a suit for specific purpose. And third is the negative covenant, my lord. I will give a written notes, my lord, but I will only take 2-3 decisions, my lord, I would like to cite, my lord. Then I will, once I file the notes, my lord, I'll hand over the compilation. But the first one is a celebrated one, Millet, Dalpat Kumar versus Prahlad Singh, Millet, 1992. 1 Supreme Court cases, page 719. Millet, I'm only relying upon paragraph 4 to 7, Millet. This is on the point of the balance of convenience, prima facie case, and where the cardinal principles of granting an order of injunction, Millet. May I read out, Millet? Order 39, Rule 1C provides that temporary injunction may be granted where in any suit it is proved by affidavit or otherwise that the defendant threatens to dispossess the plaintiff or otherwise cause injury to the plaintiff in relation to any property in dispute in the suit. The court may, by order, grant a temporary injunction to restrain such act or make such other order for the purpose of staying and preventing or dispossession of the plaintiff or otherwise causing injury to the plaintiff in relation to any property in dispute in the suit, as the court thinks fit until the disposal of the suit or until further orders. Pursuant to the recommendation of the Law Commission, Clause C was brought on statute by Section 86(1)(b) of the Amending Act of 1976 with effect from February 1, 1977. Earlier thereto, there was no express power except the inherent power under Section 151 CPC to grant an ad interim injunction as a dispossession. Rule 1 primarily concerned with the preservation of the property in dispute till legal rights are adjudicated. Injunction is a judicial process by which a party is required to do or to refrain from doing any particular act. It is in the nature of preventive relief to a litigant to prevent future possible injury. In other words, the court on exercise of the power of granting ad interim injunction is to preserve the subject matter of the suit in the status quo for the time being. It is well settled that the grant of injunction is a discretionary relief. The exercise thereof is subject to the court satisfying one, there is a disputed question to be tried in the suit, and that an act on the facts before the court, there is a probability of his being entitled to the relief asked for by the plaintiff stroke defendant. 2, the court's interference is necessary to protect the party from the species of injury. In other words, irreparable injury or damage would ensue before the legal right would be established at the trial. 3, that the comparative hardship or mischief or inconvenience which is likely to occur from withholding the injunction will be greater than that would be likely to arise from granting it. My lord, I will not read, my lord, 5, 6, and 7, my lord, but I am relying upon. So basically, my lord, what the Supreme Court, my lord, tried to is a settled possession, my lord. And my lord, I believe, my lord, in my humble submission, I tried, my lord, I have tried to paint the canvas in a manner where it is evident that the court, I'm entitled, the plaintiff is entitled, my lord, to the reliefs as claimed in the interim injunction petition, my lord. Now, my lord, the second legal proposition, my lord, I would like to, uh, argue, is, injunction as a general rule in a suit for specific performance. This is an English judgment, uh, Sky Petroleum. Again, a very chancery divisions, lordship is aware, I won't be troubling your lordship much with this one. I will only, Sky Petroleum Limited versus VIP Petroleum, 1974, 1 All England Law Reports, 954. Corresponding টা দেখে 1974 WLR 576. 74 1.
74.
Lordship will kindly take straight away to the page 578.
Last paragraph.
570, 576 at page 578. 576 is the starting, 578 I'm relying. Lordship will kindly say placetum C onwards, the second paragraph from the top. What I have to decide is whether any injunction should be granted to protect the plaintiffs in the meantime. There is a trade evidence that the plaintiff has no great prospect of finding any alternative source of supply for the filling stations which constitute their business. The defendants have indicated their willingness to continue to supply the plaintiff, but only at the prices which, according to the plaintiff's evidence, would not be serious prices from a commercial point of view. There is, in my judgment, so far as I can make out on the evidence before me, a serious danger that unless the court interferes at this stage, the plaintiffs will be forced out of business. In those circumstances, unless there is some specific reason which debars me from doing so, I should be disposed to grant an injunction to restore the former possession under the contract until the rights and wrongs of the parties can be fully tried out. This is a suit for specific performance. Specifically, there was an agreement for which entailed VIP Petroleum to supply certain petroleum to Sky, and what they did is they brought a supplementary agreement saying that I will supply, but at a higher price. That's exactly so. So we asked for the specific performance, rather Sky Petroleum asked for the specific performance of the earlier contract, which had the price that was negotiated by the parties and not a unilateral price. So that was the, I will kindly take the next paragraph and I won't be troubling much. It is submitted for the defendants that I ought not to do so for a number of reasons. It is said that on facts the defendants were entitled to terminate the plaintiffs who were in wrong. That, of course, is the very question in the action. And I have already expressed my inability to resolve it, even provisionally, on the evidence now before me. Then it is said that there are questions between the parties as to the arrangements subsequently to the making of the contract, in particularly regarding the prices to be paid, and that they give rise to uncertainties which would make it difficult to enforce any order made by way of an interlocutory relief. I do not think I ought to be deterred by that consideration, though I can see it has some force. In fact, during September and October, to go no further back, the defendants have gone on supplying the plaintiffs, on paying. There has been nothing apparently impracticable in the contract, although the defendants say, of course, that the plaintiffs have not been paying large enough sums quickly enough. So that's the and they could have said
English judgment in each line, each word, and each paragraph is having some meaning.
Absolutely. I'm a digger for old judgments, Millet. I do not know. Smallest of one another, the 1.5 page judgment, they say it all.
Correct. That's what I'm telling. Each word and each line is having its own meaning in the.
That was the beauty. I'm a movie buff. May I say this? But But I always preferred those 70s, 80s Hollywood. These are all 70s, 80s Hollywood classics, my lord. Can never go wrong. Mono Orion দেখাবো না। My lord, the negative covenant, my lord, I would cite, my lord, two judgments, my lord. Very little, my lord, but I will give a compilation, my lord. The first is Richard Wheeler Doherty, my lord. That's 1878 law reports. 3 appeal cases, 709. জায়গাটা দেখিয়ে দে তো। 3, 4, 5, 6, 7. Roshul, kindly take turn 7 pages. The 7th page, right at the top, my lord. Roshul has found the first paragraph starts with "Now, my lords." I will not place the entire part, but a little bit of it, my lord, just to show, my lord. Roshul has got that portion, my lord. Now, my lords. Now, my lords, let us look at it in that point of view. I said that there is here no negative covenant, not to turn these buildings into any other use. My lords, if there had been a negative covenant, I apprehend, according to well-settled practice, a court of equity would have had no discretion to exercise. If parties for valuable consideration with their eyes open contract that a particular thing shall not be done, all that a court of equity has to do is to say, by way of injunction, that which the parties have already said by way of covenant, that the thing shall not be done. Period, my lord. And in such case, the injunction does nothing more than give the sanction of the process of the court to that which already is the contract between the parties. It is not then a question of balance of convenience or inconvenience or the amount of damage or injury. It is the specific performance by the court of that negative bargain which the parties have made with their eyes open between themselves. And I rest here, my lord.
And the cardinal
Lord Keynes, my lord.
Secondly, they have today also, they do not dispute the agreement procedure.
And today, my lord, may I, my lord, say this? They had, even today, have not disputed the agreement for sale before this court.
Yes.
So, my lord, that stands. All they had to do, my lord, is to, my lord, execute and convey the property in my name. This entire process would not have been initiated if they were ready and willing to do their part of the obligation within the time stipulated under the contract, which they did not do. Yes, that is my submission, my lord. One more is Vijaya Minerals, my lord. I will not, my lord, trouble your lordship much, my lord. Where, my lord, I will not place much on the last portion of the last page of the judgment, my lord. Vijay Minerals, so check again. 1990, AIR 1996, Calcutta, page 67, 1996, 1 CW CHN 318. I will straight away, Miller, take your lordship to the last smallest paragraph is paragraph 91, very last page, Miller. Yes. The above, Miller, 90 is, Miller, 2 lines, Miller. The above decision has no application to the facts of our present case, whether the plaintiff is seeking to enforce a negative covenant. 91 is the judgment and the decision in the case of Ranganathan Ramaswamy or Dalpat, Miller had cited Dalpat, Miller, reported in 1992 1 SCC 719, refers to the principle of granting interim order of injunction which are well settled. However, in the case of negative covenant, the concept of balance of convenience and damages being adequate remedy has become less important as has been laid down in the decision of the House of Lords in the case of Richard Willard Doherty versus Jim Claxton Alman. Willard, I cited that one, 1878, three appeal cases, Millard, at page 720, Millard. So, Millard, this judgment, Millard, had discussed the entirety of when a negative covenant should be looked into and when the court will be absolute in protecting the plaintiff's right with regard to if there is a negative covenant to protect the rights of the plaintiff, Millard, till disposal of the suit. Millard, this is, Millard, I will conclude here, Millard, and I will prepare a short written notes, Millard, and there are other judgments also, Mono Orion and all those judgments are here, Millard. I will.
Let they complete.
Yes, absolutely, Millard, absolutely.
Do we?
I will just take your leave, Millard.
Not ready today.
I have to consider this judgment.
Yes, let them.
Facts, I will not take much time. So you can keep another day and then we can complete it on that day.
Self-defense appearing for the plaintiff.
Sorry, Millard.
Dependent. Counsel for the plaintiff has concluded his argument in connection with GA2 of 2023. Counsel for the defendant prays for time to consider the prays for time to give reply and prays for time. Consider the submission made by the counsel for the defendant. Let the matter appear on 18th March at 3:45. 18th March 3:45.
We cannot preempt the document. That's the worst thing I can do.
Difficulties. Any other thing?
First April what time? 12 noon.
I won't say a word.
Advocates
I won't say.
The date.
Mr. Kushal may not be here.
আমি জার্মানি যাচ্ছি end of April.
April you will be here or not?
Yes, I will be going to Germany, Millard. End of April. I have few lectures on a weird subject, Millard. They want me to deliver lectures in 5 universities with regard to impact of GATT post the Cold War era.
Yeah, good.
So the worst part is, Millard, I have to study again. The best part is, Millard, I'm learning again.
Again and
Memorizing. Although I do not know whether India has any impact with regard to this, Millard, until and unless there's some, because international trade in this part of the country is not much.
Now that the WTO has come in,
nowadays
some of
So GATT has merged with the
WTO and all the things is there, but the country is taking
still,
the
the
step.
international law has its meanings. So much obliged.
Thank you. Sure. For orders.
This is my exception. My lord will recall this was my application.
Who is for the other side? Morning also.
They're
not
here.
there?
There was a final exception to the audit report filed by the receiver. This was an application for discharge of the receiver on the grounds of gross misconduct and various other there. Your lordship.
You are appearing, madam?
My lord, for the bunch of respondents, 5 to
5 to
7, yes.
What about the plaintiff? Where is Mr. Arindam Paul?
He was waiting. His item is the next one. He.
Same matter.
Oh,
Same matter. The GA is different.
Oh, G is different. His application for injunction, the receiver is standing and helping a club to construct clubhouse on the suit premises. He's standing there and the photographs are there. And this application we are actually supporting. This is the conduct of the receiver. Standing in the spot, helping the club in spite of an order of injunction there.
Yes.
Now, if your lordship sees my exception to the report, your lordship
GA8 filed by you? Who has filed the
is,
GA8?
yes, GA8 is my application. Now,
receiver.
yes, we had some difficulty in filing this exception because we got hold of documents. What happened? The predecessor of the parties in this suit in 1966 filed the partition suit in which receivers were appointed from time to time. The last receiver was one learned advocate, Paramita Pal. She was discharged because the suit was dismissed for default. In 2014, she was discharged by an order of Justice Sen.
After 66?
Suit was filed in 66. Suit was dismissed in between, but no one knew about it. The suit carried on. Some properties were sold through court and all that. Ultimately, the suit was dismissed in 2014 by an order of court. The receiver was discharged. The learned receiver filed a report with the register, audited report, that how many premises were there, how many tenants were there, what was the rent, which I have annexed as Annexure B to my exception. From that, your lordship will see the annual rent of the premises, because I have given the calculation in my exception. The annual rent is approximately, first kindly see the report filed by the learned receiver. Annexure B, page 19.
Annexure B. Annexure B.
Annexure B to the exception which I filed.
Exception.
Yes, your lordship, I'm appealing for the receiver. We have received the exception yesterday at 1 p.m.
What?
The exception, your lordship. So we are not prepared. We are not prepared right now. We need some time.
What you will prepare?
Counter your
The,
lordship.
huh? Exception to exception.
I'm not prepared. Need little bit of time.
We have visited several times. Sometimes it's closed. He's saying, no, come back later. This is the conduct of the receiver. But kindly see the report on the prima facie, see what he has done.
Yes.
Now, this is the accounts, the statement of accounts for the period in which the learned receiver was engaged. This was filed by Paramita Pal in suit 1166 of 1965, and this was filed in 2014.
Yes.
This was filed. Now, from this report, your lordship will...
It was filed 2000 April to December and filed on March 2015.
15, yes, 15. Now, from this, your lordship, I've made the calculation in my exception. The annual amount of rent is approximately, it's 43 lakhs approximately, 43,000 per month. Approximately 5 lakhs odd and something. So if I calculate on this basis, the rent for which the present receiver has filed the report comes to more than 30 lakhs. 30 lakhs. Now, the period 14 to 17, November, she was discharged. From 17, 2.5 years. That comes to approximately 30 lakhs. So 43 lakhs would be the income from the estate this period. On the basis, not only that, in my application, I have annexed, in violation of the order of court, he has inducted tenants. I've annexed the receipts in my application, because if your lordship compares the report which has been filed in the earlier suit of the receiver, these tenants were not there. this was inducted after this learned receiver was appointed. So he inducted about 7-8 tenants and he regularized illegal tenants. Because if your lordship calls for the record of that suit, your lordship will see that the list of tenants there do not match the list of tenants. So what he has done, he's breached the order, he's inducted these tenants, he siphoned the funds. Now, we are talking about 2014. The rent should have been increased according to the order. Those have not been done. There is a shortfall of, he has submitted the accounts of 1 page. And he has shown 6 lakhs. In 6 years, he received 6 lakhs. 6 years. There is no mention of what happened to the period from 14 to 17. So either there could be two things. He has not collected, he has been negligent, or he has collected it, which is not reflected. Second of all, the report does not reflect, his report does not reflect the municipal rates and taxes, which had to be paid by him. Third is that in the whole vicinity of city of Calcutta, he did not find a chartered accountant. He got this report to be filed by a CA who appears to be from a very small village in the district of Nadia. Now, kindly take my points. Kindly take the report filed by the learned receiver, which is...
Let me, who is for the plaintiff? Yes, what is your...
My lord, I am supporting the application and I am supporting the exception taken by the defendant.
So why you are not appearing? In the morning also you are not appeared today when the matter is called? Yes, you are for the receiver. Yes, what is your submission?
My submission is, yesterday at 1 p.m. we got this exception.
Correct.
I need a little bit of time.
For what? For what?
To argue on the exception. There are many mistakes which receiver said. So he wants to argue about it. I need a little bit of
Where is the receiver?
He is not right now presenting.
How soon you will file? How soon your receiver will come court?
1 to 2 weeks.
My lord will kindly take 1 minute more. Just let me show your lordship paragraph 12 of my exception. Paragraph 12.
Yes.
This is, my lord, I would submit fraud at its highest level. See what is done. Paragraph 12. There appears to be no figure in the bank balance of Canara Bank, Hare Street branch being account number such and such, and the cash in hands also shows nil. The rents collected from the 3 premises have been incorrectly and falsely reflected without any supporting documents. The said 3 premises, which would fetch approximately rent of 31,66,000, or if according to the earlier report, the annual rent which was being collected by the erstwhile receiver would receive nearly 5,27,000 such and such per annum. The receiver has manipulated some figures, and such figures are not based on any evidence. Tried to mention miscellaneous receipts he received on the name of such receipts, that the miscellaneous expenses are not recorded. It had withdrawn the deposits from the register original side of the Honorable Court and deposited the same with Canara Bank. No such date has been shown or does not reflect in details how much rent he had collected for the said 30 months. That is from December 2014 to July 2017. It would therefore be clear that the rents for the said 30 months have not been collected or siphoned nearly 43 lakhs, rupees 30 lakhs, 19 of such and such, which appears to be a prima facie been siphoned off by him. The receiver has not properly reflected their figures anywhere in said report. Remuneration and the clerkage seems to be extraordinary, shown nearly 30%, which is unreasonable. Moreover, such remuneration has not been fixed with the consent of the parties according to the said order dated 24 July 2017, passed by the Honorable Justice Shomen Shen. Printing, stationery, and other conveyance also seems to be inflated, as the receiver has hardly held any meeting, and therefore question of such expenses does not arise and seems to be unreasonable. Moreover, the receiver was supposed to take steps for enhancement of rents, which he failed to do. There is no mention of figures relating to payment of municipal dues and other government dues. The receiver has failed to file proper half-yearly accounts. Then the receiver has inducted several tenants in breach of the said order passed by the Honorable Justice Shomen Shen, which he was prohibited to do, siphoned of huge amounts of premium did not account for the same to the detrimental to the estate and sued properties and concealing and not reflecting such facts in the accounts, which is prima facie incorrect and false. Tried to mention that the rent which has been reflected in the report is without any evidence, and the receiver deliberately suppressed the true and actual rents and income received from these premises. This is my case. Paragraph 12 is my case.
Yes.
Yes,
I
Your
am
Lordship.
fixing a week. Come on that day. If you will not come,
My lord, my lord, item 3, my lord, there is another application GA9, my lord. My lord, there is a property at 58J and 58K, Ama Street, man, where there is vacant land, my lord.
take this microphone.
My lord, there is a property at 58J and 58K, where my lord, there was a vacant land. My lord, some trespassers have occupied some of the portion, have
Is
erection.
not the receiver on that plot?
Yes, my lord, that is under the receiver,
Yes.
my lord. But that
is
is why another, my lord, we have. My
Tell
lord,
your receiver, give the report with regard to the what is the survey number?
GA9. Premises number 58J and 58K.
the construction is being made by the local club in connivance with this learned receiver.
Your
He's
Lordship,
standing
I
there.
haven't received the GA9. It is not served upon us.
Not necessary.
Okay.
You are not the party, you are the receiver. You are the officer of the court.
But
you have
we
to
do not-
protect the property.
But we do not know what is in GA9.
I will say this court will direct
He's standing there.
on the last
Paragraph
occasion.
19, page 90, my lord, he was standing there when the photograph was taken, my lord.
Yes.
Kindly come to
Page 18 and 19, kindly see.
19.
He's standing there, boldly he's standing.
He was repeatedly he was informed that the property was misused, the trespassers was going on, but he has not taken any steps, my lord.
So and so appearing for the plaintiff. So and so appearing for the defendant number 8. So and so appearing for the 5, 6, 7, 9, 10 within bracket small a, small b, 11, 12, 13 small a and small b. And what about the 14?
My lord, I'm appearing for defense.
So and so appearing for the defendant number 14. Full stop. The counsel for the defendant number 8 has filed exception to the report filed by the receiver after serving the copy to the receiver. Full stop. Learned counsel who is representing the receiver prays for time, prays for a week time. Full stop. Full stop. Counsel for the plaintiff has filed an application being GA9 of 2023. Praying for, what is your prayer? Praying for an injunction.
Interim injunction, judges.
Praying for an injunction restraining the trespassers for trespassing into restraining the trespasser in the premises being 58J and 58K Amrest Street, Kolkata 9. Full stop. The plaintiff as well as the defendants have submitted before this court. The construction is being carried out in the said premises in the presence of the receiver, but the receiver has not taken any steps to stop the illegal trespasser and illegal trespass of the persons and illegal construction of the building in the said premises. Considering submission made by the counsel for the respective parties, the receiver is directed to submit a report positively within a week with regard to status of the property situated at 58J and 58K, and to specify that whether any persons have illegally occupied the premises or any construction is going on. Let the matter appear on, give the date. 1 p.m. Huh? Let the matter appear on, today we are on 1st, no? Let the matter appear on 12th February 2024 under the heading orders. It is made clear that if the receiver fails to appear before this court and to submit the report as directed above, appropriate order will be passed.
My lord will fix a time because
No,
this
for
will-
order, that's why it will come
Oh,
first.
okay, very.
No, it's my application for it's my application for restoration
Restoration
of my probate proceeding which I had
My lord, sorry to intervene, my lord. It just kept my mind. 12th time out of station, your lordship, any day except the 12th.
Then 13?
13 just the day before
Huh?
Saraswati. Day before Saraswati Puja, Malad, 11th, Malad.
I can't hear you.
Malad, 11th, Malad.
11th?
Yes, Malad.
Yes, 11th, the whole day I am free.
Yes, 11.
Both will appear. Whole day I am free. I have no work.
He is too busy. He is too busy.
Then 9th.
Ninth.
9th? No.
Yes, 9th.
9th February.
9th.
Inform the other side. Who is the receiver? Who is appearing for the receiver? Inform that.
9th.
9th February under the heading orders. Yes.
The probate proceeding instituted by the applicant before your lordship was dismissed for default on 5th September 2023.
Correct.
But in the application, it has been stated that the petitioner became aware of that in January 2nd. Not aware of January 2nd. January 2nd, petitioner inquired, the advocate on record thereafter.
Not necessary of the aware once the petition has filed in there 2015.
Yes, but thereafter,
And 2023, then the petition never bothered to take the steps.
in 2022, the caveat was lodged.
So
Once the caveat is lodged,
let it be pending before.
it became a contentious cause, not a non-contentious. The number had to be also changed. It's PLA.
But
Yes,
application
yes.
Who will made an application for contentious cause?
Application is not necessary.
Not
The court,
somebody
court
has to appear before this court.
Yes. So my instruction is that
Let it be dismissed. You go and challenge.
it's a dismiss for default for.
2015 matter.
But there was no fault on our part.
Appeared.
Kindly appreciate.
And you are again submitting that there is a caveat. The caveat
In 2022.
You should more
Caveat in
vigilant on that day.
2022, Millard. It was not pending because of me. Caveat. It was pending in the department. Lordship knows the probate department.
Sir, I know.
Thereafter, in 2022,
What is
they filed
going
the
on in the testamentary department? All the things I know for the last
I bow down, Millard. Now, in 2022, somebody files a caveat. And Millard serves me a copy of the affidavit in support of caveat. But then, Millard, I got stuck.
Because I don't think before my determination any application has been listed.
Actually, Millard,
when I taken the determination, I find that from the 2000.
Yes. All old
cases. All the pending. Neither the petitioner is taking steps, nor the cavator is taking steps, nor the department is taking steps. And showing the date, it is listed before the High Court. 50,000 matter is pending.
The less I speak about this is better for me, Miller. I only say in 2022 they served the affidavit in support of caveat. Only then my time started for conversion. That we mentioned once or twice. Then there was a change of advocate. Early advocate on record was there. The client wasn't happy.
I find when I taken the determination, I find only 200 applications are pending, but none of the application was listed. Out of the 200, 160 or 70 defects for the last 10 years. Nobody has bothered to cure the defect. Nobody has bothered to place before the court. Nobody has bothered to proceed with the matter. When the court has taken dismissed, then starting the matter restoring. Once I restore, then again you will sleep.
Lordship will bring it in the next day. Today Lordship is restoring it. Tomorrow it will be listed. I'll take immediate steps. Once the change of advocate, thereafter Miller, things get better, Miller. So now, Miller, I would say, Miller, I am ready.
The petitioner has filed an application being GA3 of 2024, praying for recalling of the order dated 5th September 2023, wherein this court has dismissed the PLA 1292 of 2015 for default. Mr. Counsel for the petitioner submit that though the application was filed in the year 2015, but the caveat is filed only in the year 2022. But due to inadvertence, the petitioner could not take steps, and on the date fixed when the matter was called, the petitioner was unaware of the date and accordingly the petitioner could not appear before this court to move the application. Consider the submission made by the counsel for the petitioner, peruse the application, sufficient. This court find that the sufficient cause has been shown. Accordingly, the order dated 5th September 2023 is recalled. PLA number 292 of 2015 is restored in its original file.
Grateful.
GA number 3 of 2024 is disposed of. Let PLA number 292 of 2015 be placed on 19th February 2024.
Lordship may also direct for renumbering, which should be the testamentary suit. Very well.
Restoration
Very well.
completed.
I'll come. Grateful.
Next.
My lord, I appear for defendant bank.
Well, I appear for the plaintiff, your lordship.
Yes.
An application under Order 6, Rule 17, my lord, for correction of the name of the defendant, my lord.
Correction of the name of the defendant.
Yes, your lordship.
In the suit.
In the suit, my lord. Previously, it was known as State Bank of Travancore, but my lord, it was subsequently taken over by the State Bank of India, my lord.
State Bank of
India. State Bank of India.
Achha,
But may I just indicate at page 9, your lordship, the necessary corrections has been done.
Which was the
shown in reading?
You are appearing.
Yes, my lord, I am appearing for the bank, my lord. My lord, only thing they wanted to amend their this cost title
Cost
of
title of the
cost
defendant.
title, but the we have not connected with 44 Park Street, Kolkata 7,60,000.
My lord, only one thing, your lordship, will kindly come to page 6 once.
6.
Page 6, Annexure A. My lord, the circular whereby the State Bank of Travancore had been acquired, had been named as State Bank of India, my.
State Bank of India, but
Yes, your
which
lordship.
branch it has been taken into? So this has been Travancore has come to the State Bank, of India.
Yes.
But which area, which branch has been taken by which branch?
My lord, will kindly come to.
My lord, kindly.
Can you
My lord, will kindly-
ascertain? Can you ascertain which branch is
Yes, my lord. 195 MG Road, opposite
where
Bada
it
Bazaar
is?
Police
Where it
Station.
My lord, will kindly come to
It-
para 7 at page 3 once.
My lord, may I assist? Kindly come to page 3.
Page
What?
3?
Page 3, paragraph 7, proposed amendment.
Yes.
State Bank of India carrying on business from its Malik Bazar Saket building, 44 Park Street, first floor, Kolkata 7,16,000. We have no connection with this address, but second part is correct. The
195
SME Park Street branch 70248, second floor, 195 MG Road, opposite Bada Bazar Police Station, Kolkata 7,00,000.
So this 44
is-
Park Street has been merged with the SMSC branch, SMSC Park.
No, 44 we have not connected at any point of time, State Bank of India.
No, State, because the
State Bank of Travancore was there.
So how you got the 44 Park Street?
My lord, State Bank of Travancore was there with 44 Park Street, your
Correct.
lordship.
Now that has been gone.
That has gone. My lord, will kindly come to the proposed amendment at para 7, your lordship. Yes, I have specifically stated.
Para 7.
Yes, your lordship, the paragraph which was shown.
Which
my
I
lord.
was referring, my lord.
My lord, will kindly come to the proposed amendment once. State
You
Bank of
mentioned
India
that
carrying on business from its.
44 Park Street you have mentioned.
Yes, your lord.
There is no bank in the 44 Park Street at
No, my lord,
present.
the second one.
So that you have to delete the Park Street. Second one is accepting that.
Yes.
My lord, will
Issue the notice.
whatever your lordship thinks.
As per you, SME Park Street.
Yes, SME Park Street, 195 MG Road, Kolkata 7,07,000.
So I am giving leave to delete that 44 that
Up to Kolkata 7,16,000. It should be
Malik
deleted
Bazar
from.
Street Building 44 Park, Kolkata 16. This is to be deleted.
And also, my lord, it's referred as and also at.
And also at, but he is telling that the 44 there is nothing.
Yes, your lordship, I could
So
understand.
then you will be in trouble in future. So what can be done?
And will kindly give me leave to delete this?
Any objections, sir?
No.
So appearing for the plaintiff. So appearing for the defendant. The plaintiff has filed an application being GA 2 of 2024, praying for amendment in the plaint by correcting the address of the defendant State Bank of India. Full stop. Counsel for the plaintiff submits that the State Bank of India Travancore has been merged with the State Bank of India SME Park Street branch within this one. There is no page number. Proposed amendment. This one. 44 Park Street, first floor, Kolkata, 7. Merged with SME, merged with Malik Bazaar, Saket Street, building 44, Park Street, first floor, Kolkata, 70016, and also at SME Park Street branch within bracket 70248, comma, second floor, comma, 195, comma, MG Road, comma, opposite OPP, Bura Bazaar, Police Station, Kolkata, 700007. And as such, the address of the defendant bank is to be corrected from the State Bank of India to State Bank of India, comma, what was the earlier?
Well, it's State Bank of Travancore.
State Bank of Travancore to State Bank of India. Counsel for the defendant draw the submitted that it is admitted that the State Bank of Travancore is merged with the State Bank of India, but the address is SME Park Street branch within bracket 70248, second floor, 195 MG Road, opposite Bura Bazaar, Police Station, Kolkata, and not at the 44 Park Street. In view of the submission made by the counsel for the defendant bank, comma, the counsel for the plaintiff is given liberty to delete the address mentioned in the cause title as Malik Bazaar, Saket Street, building 44 Park Street, first floor, Kolkata, 70016. The consider the submission made by the counsel for the respective parties. This court find that the amendment as sought for by the plaintiff is formal in nature and will not change the nature and character of the suit. Accordingly, prayer A to D of the master summon is allowed. GA.
Well, the department should be directed to carry out amendment.
That is prayer is there.
I will give
2 of 2024 is disposed of. Full stop. The plaintiff. Where is the reaffirmation? This amendment is there. Okay, it is there. The plaintiff is full stop. The plaintiff is directed after the amendment. The amended copy of the plain may be served to the counsel for the defendant within a week thereafter.
Malaris, give me 2 weeks time.
That what you mentioned.
Yes,
time is mentioned, not mentioned.
No, I don't think it's mentioned, Your Lordship. That's why I was humbly beseeching Your Lordship.
The department is directed to carry out the amendment within 2 weeks from date. Full stop. The plaintiff is directed to re-verify and reaffirm the amendment print within a week thereafter.
Great. Great.
Much of it.
I appear for the plaintiff, madam. Yeah.
Yes.
I appear for the defendant.
Witness action?
Yes, was. And the plaintiff's witness was in the box, my lord. It was. আচ্ছা অ্যাপেলের সাইড আছে কি অ্যাপেলের সাইড আছে অ্যাপেলের সাইডে হ্যাঁ আধ ঘন্টাই হবে হ্যাঁ কোথায় গেল আসুন
3:30, na? How much time you will take?
But I think there's a 3:30 at or appellate side.
You will continue.
No,
Okay,
no.
okay. Release other man.
Yes, yes, yeah, that can be. Yes, yes, yes.
3:30 you will continue.
Yes, yes. Eh? Wait up. No, no. I thought if I got 1 hour, I would have completed the chief today, but I saw there's a appellate side. Yes, yes. No point in. These are 3:30. শুধু
PASU, PATI, MAHA, Mahapatra, MAHA, PRA.
কাগজগুলো দিবি আমাকে চল এটা আগে ওথ হয়ে গেছে আগে হ্যাঁ ও পশুপতি মহাপাত্র Mr. Mohapatro, kindly tell what happened to the cargo which was insured under the insurance policy with the defendant dated 13th of June 2018.
Please repeat again.
What happened to the cargo which was covered under the insurance policy with the defendant?
On 14th June 2018, early morning, the cargo caught fired and it was
fired
and it was totally damaged, totally destroyed, damaged and destroyed.
In which place did this fire take place?
On sea. On sea.
At the sea.
At the sea.
SEA, huh? Sea,
TSEA, সমুদ্রে when did the plaintiff get the information about this fire?
15th June onwards, every day there was news in newspaper regarding this vessel, and we are getting information accordingly through newspaper.
Other than the newspaper information, did the plaintiff get this information from any other source?
Yes, from shipping liner, we received this message also.
What steps did the plaintiff take after it got the information about this fire of the goods? There was this fire.
We submitted claim letter to HDFC Ergo.
We submitted claim letter to
HDFC Ergo.
HDFC Ergo, নামটা ERGO, Ergo, Ergo. Do you remember when this claim was submitted by the plaintiff to the defendant?
It was on 27th March.
What happened to the claim that you had submitted with HDFC, with the defendant?
HDFC rejected our claim.
PD 11. I'm showing you a letter, a copy whereof a copy whereof is appearing as PD11 at pages 73 and 74 of the judge's brief of documents. Kindly tell the Honorable Court, what is this document?
This is the this is the letter sent by HDFC Ergo, rejection letter of HDFC Ergo against our claim.
Is this the original of the said letter which you received from HDFC Ergo?
Yes, it is original letter.
Can you tell the reason why HDFC had rejected your claim?
Actually, against our claim letter, HDFC deputed one surveyor, J. Basir and Associates.
Surveyor?
J. Basir and Associates. And based on their report, HDFC rejected our claim. They have shown two reasons. Number one is, as per them, as per Basir report, the ownership of the goods, since the sale has been done, sale has been done on sea before the incident through high-social agreement. As per them, the ownership of the goods has been transferred from Desmet to Tata Steel. So
from Desmet, DESMET.
DESMET Desmet to
Tata
Steel.
So there is no Desmet is not having any insurable interest. This is number one reason what they have shown.
Yes, next.
Number two, we have issued invoice to Tata Steel before the fire incident. So HDFC claiming that since we have issued invoice to Tata Steel, so title of the goods has passed on and we are not eligible for the claim.
May this document be tendered, man. It's in original from the defendant.
What one? Last exhibit?
Last
Exhibit I.
I. My lord will give me a minute.
Yes, next.
Next. What steps did the plaintiff take any steps after HDFC rejected its claim?
Yes, we again sent letter to HDFC. As such, our managing director, Mr. H.D. Bhasha, drafted and issued the letter. H.D. Bhasha.
Patra.
H.D. Bhasha.
Bhasha.
VASA. Bhasha.
Pananta bole din na baba.
Drafted and issued the letter in presence of me, and that letter was sent to HDFC through email from our official email ID.
I am showing you a letter dated 27th of March 2019, being PD13. A copy whereof is appearing as PD13 at pages 82 and 82 to 84 of the judge's brief. Kindly tell the Honorable Court, is this the document you referred to in your last answer?
Yes, this is the letter.
Mr. Mahapatro, you will find the document which I handed over to you is a printout of the said letter.
Yeah.
Kindly tell the Honorable Court, this letter was sent from whom? From whose email ID And to whose email ID?
This letter was sent from our company's email ID to HDFC grievance cell and copy to Anupam Ghosh of HDFC and other people, Mr. Vash. And the same letter was copied to me also.
The same letter was copied to me also. How did you get the printout of this letter?
This is from my computer. I got the printout in my office.
Well, এটা কত
J,
হবে? হ্যাঁ,
exhibit J.
চুপ করে চুপ। I J পরেরটা দে। Did তাড়াতাড়ি করে দি। Are you aware whether the defendant HDFC ergo give did actually send any reply to this to the plaintiff's letter dated 27th of March 2019?
Yes, they replied us.
I'm showing you a letter dated 16th of April 2019 being PD 14 appearing at copyware of at pages 85 and 86 of the judge's brief of documents. Is this the document you referred to in your last answer?
Yes, this is the document we received.
Is this the original of the letter that
Yes.
the plaintiff received from the defendant company?
Yes, this is the original letter.
Original. Well, let me remark, this is a defendant's document in the original. The defendant document.
K.
H I
Exhibit K.
K. কি অবস্থা আমার দেখেছিস? হ্যাঁ, জানি না। Bit. Yeah, just a minute. Are you aware as to any steps, any further steps taken by the plaintiff after receiving the defendant's letter dated 16th of April 2019?
Yes, we file a suit because HDFC even grievance cell also rejected our claim. So finally, we have no other option but to file the suit.
To file the suit. I am showing you a document being PD 18, PD 15, sorry, PD 15 at pages 87 and 88 দিয়ে দে। দেখে আমি চেক করে নিই একবার। হ্যাঁ, ঠিক আছে। 87 and 88 of the judge's brief of documents. Kindly tell the Honorable Court, what is this document?
This is a letter which was issued by our managing director to HDFC grievance cell regarding the claim.
How did you get hold of this letter?
This letter was issued by our managing director, Mr. H.D. Bhasha, and here also copy was marked to me, and I took the printout from my computer from our office.
Is this the true and correct printout of the original email?
Yes, this is true and correct copy of the original email.
And may this document be marked as exhibit. This is আর কি আছে? আর একটাই আছে। Oh, sorry. Exhibit IJKL. ওটা কেন দিচ্ছি কেন? Oh, না কোথায় দিল না তো এটা কি আছে নাথিং রিগার্ডিং ক্লেম নাম্বার দেখলো না বাদ দাও apology for inconvenience caused neither here nor there দেবো ও ছেড়ে ও এসো এসো ওখানে কথা হচ্ছে আমি যেতে হবে যাচ্ছি আমি এক্ষুনি চলে যাবো you had deposed that the defendant company appointed a surveyor namely J. Basir and Associates.
Yes.
Did the defendant inform the plaintiff company prior to appointing the said surveyor?
No, they have not informed us.
Did this surveyor approached the plaintiff company for any information prior to filing of the report?
No, they have not approached. Rather, when they send the report, they have marked a copy to us.
When they send the report, the copy were marked to us.
To us. Saved another answer. মনে হতেও পারে জানি না দেখে নিচ্ছি হ্যাঁ you had deposed today that one of the ground of rejection of your claim by the defendant company কোথায় গেল রে just a minute যা বাবা no 73 sorry one of the ground of rejection of your claim is that the tax invoice was raised by the plaintiff in favor of Tata Steel. Did the plaintiff receive payment for the goods from Tata Steel against the tax invoice dated 11th of June 2018?
No, we have not received any payment from Tata Steel because as per the HON'BLE agreement, payment terms was 15 days from receipt of goods physically at port,
15
destination port.
15 days after receipt of
After receipt of material at port, at destination port. But the material, the goods were destroyed on sea. So since they have not received physically the material, the goods, Tata Steel has not given any payment to us.
Plaint একবার দিও দেখে গল্প হয়ে গেছে
take this.
Show him the plaint usual questions shown the plaint বলছি ওইটা না ওইটা বলছি kindly tell the honorable court who has affirmed and verified this plaint পেজটা একটু খুলে দেবেন পেজ 28 29 এসব আছে
Ankur Patel.
In which capacity he had verified the plaint?
He was manager in our company, but he has left. He is no more with us.
Are the contents of the plaint true and correct?
Yes, it is true.
It's true. Number eight, only one thing is one document was gone as marked for identification. But you will kindly see the document. I just tell you what the difficulty.
Which document?
Which is in the judge's brief.
What?
No. This page 7 to 33. which is the purchase order issued by Tata. Though, but I feel that is not of much of importance in this proceeding, but still this is, I have put some questions to the witness in the deposition. The difficulty we face that it came by email. So we don't have the original copy of it. Now, she will see the questions put to him.
No, but they are admitting that you have sold the material to the.
They're admitting I have sold them it. Exactly. They're admitting that this is their case.
Their case.
Their case. They have sold the material. So ownership has transferred. No, I was about to say caveatable interest. No insurable claim. So that's their case. So this document, which is the purchase order of Tata Steel, this has gone as marked for identification. Now, I've asked my witness to check in the computer. So he's carrying his laptop. So he can show this document which has come from Tata from his inbox directly. So if this document can be marked as an exhibit.
But 65B.
65B, I'm carrying an affidavit also with regard to others. But I feel, man, in the commercial matter, it is order, this amendment statement of truth covers 65B to some extent.
No, but it was filed with that.
Yes, with the plaint.
No, but proving that.
Oh, proving that.
Proving that.
In any event, I'm carrying a 65B certificate.
Proving the electronics document.
Electronic 65B. 65.
If it is not denied, if it is not admitted.
Admitted. Now, I have also made a, so far, what? Huh? Oh, email that's so I have the emails which are there, which was given to me. The emails. So, but what I found, which is not important here, but what I found from the 65B, if the witness can produce the original instrument and can show it.
Not instrument. If the witness to prove that he has obtained the electronic document from his system and it is
still available in his system.
And it is correct.
Correct. And I'll just put few questions on that so that I can mark it. I have a document at the net.
But now my original side.
Oh, you have Apple side. Okay.
What is your defense?
But let them offend first.
Offense. No, defense is there in the document only.
But I'll not go hyper technical. So, in the event, my learner.
Why not settling?
There is no question of settling. There is no question of settling. There is no question of settling. I'll show from the facts of the plaint itself that it is a case where the plaintiff, perhaps after the incident, the insurance was.
That is different thing.
So there is no.
That's why, see, with regard to the insurance claim, 3 things is required. On the date of the incident, at the time of the incident, the insurance was valid. First thing. With regard to the ownership of the insurance policy.
Insurable interest. Insurable interest.
Third is that what is the valuation of it? These are the 3 things.
Valuation I am not going into. Now, with regard, coming back to the phrase insurable interest, I say that no insurable interest was created in favor of the plaintiff, and in fact, it could never have created.
Okay.
So, Malad,
it's not only on law, but on facts itself.
But I may be taking 5 minutes.
So you come ready with
yes,
the cross-examination
yes.
on
That is the only thing. For this purchase order, 5 minutes more on the chief and then the cross-examination. But the witness may step down. Anyway.
Sense offering for the plaintiff, sense offering for the defendant. Full stop. The plaintiff witness, first witness.
Yes, PW. I have only one.
Witness is present and examination in chief resumed. And during his examination,
is a commercial matter any day.
Documents.
Koro amar kichu darkar nehi. Amar ja bolbe. Witness
to K. I to L.
Kove dilo?
Due to paucity of time, examination chief could not be
completed. Oh, no, exhibit.
The examination chief is deferred. Counsel for the plaintiff submission only he will take 10 to 15 minutes to complete the cross-examination, examination in chief. Accordingly, examination full list the matter on 28 February. What time? But there is no other matter. What is hearing nahi hai? On 28 February for further examination chief and cross-examination.
My lord, subject to my lord's convenience, my lord, may your lordship kindly keep it at particular time, my lord, maybe.
That's why commercial is the first. That's why I'm asking.
The other hearing matters, Honor. I have a witness action.
Since the witness is coming, my lord.
No, I know. I will deeply oblige.
May I have my lord's indulgence, my lord? May I have my lord's indulgence, my lord? Item number 24 and 25. I'm appearing for the plaintiff, my lord. Tomorrow, my lord, I have a personal difficulty. Lordship will kindly keep this on Monday, my lord.
Who is for the defendant?
My lord, I'll serve them notice, my lord.
But that is the problem.
I am appearing for the plaintiff, my lord.
Any juniors are there?
My lord, that's the difficulty, my lord.
See, what's happened, I will adjourn tomorrow. The defendant will come in my
I'll serve them a notice, my lord.
Maybe so.
All that I'm saying.
I will take care of it. 24, 25.
Very well, I'm grateful. I'm grateful.
Yeah, मैंने तो note कर लेना. Not no. कल तो रहेगा, but he will not appear.
I'm grateful, my lord. I'm grateful.
That Jalpaiguri matter is there.
My lord, may I be permitted to mention one contempt application, my lord? But this is an order passed by my lord on 17th of May 2022. My lord, I mentioned this matter.
17th of May?
17th of May 2022. Contempt application was filed there in the year.
By this court?
Yes, my lord.
My order?
My lord. And thereafter, more than 10 times I mentioned this matter before my lord. Till today, not appearing in the list.
Give that.
In the backside of the I have written the date of the order as well as the file was gone down to the department of 19th of May. Retired person getting nothing.
No, but 2012 matter, I have disposed of the matter.
Yes, my lord.
Give to the DR. Yes. No.
My lord, item 1, I'm for the petition and this application, my lord.
My lord, I appear for the contempt. My lord, we have preferred an appeal. Your lordship on the last occasion was pleased to adjourn the matter. My lord, the appeal was admitted and my lord, direction was given for service. And my lord, in terms of that order, my lord, I have already served on my learned friend over there.
My lord, kindly see the orders of my lord division. This is the my lord 4 times, my lord. 4 occasion, my lord. They are my lord. In name of appeal, my lord, they are taking the time. My lord, kindly see
my lord, on the last occasion, the appeal was not admitted.
No order has been complied from the my lord contempt.
Like this. My lord, on the last 2 occasions, my lord, the appeal was not heard out. Now at this time, my lord, the appeal was heard out. Directions were given for service of the copies. My lord, on the other side, we have served it to them. My lord, I have also annexed the, my lord, forwarding letter of service to the other side as well.
My lord, there have no interim my lord order on my lord's order. There have no stay order on my lord's order.
Have you received the 1,000 rupees?
Yes,
no, my lord. No, I have not received.
My lord,
and still, my lord, still no application has been served.
Do not shout like this. Kindly, my lord, see, I have annexed the letter as well. My learned friend is shouting that he has not received.
My lord,
kindly
he compelled to shout me, my lord.
Kindly see. The first page is the, my lord, receipt signed by him. My lord, that he has received the 1,000 rupees as directed by the honorable.
My lord, I want to see my lord's signature. My lord, from my lord, client, I have not, my lord, got any.
Submit on instructions. Don't say like this before the court. पांच पेज तो दे
কে দেবাশিস রয়
যা তোমাদের ক্লার্ক সেই
না আমাদের কোনো ক্লার্ক
এটা যে সই করেছে
my lord I object my lord
Okay, whatever, that is not my lookout. It's the division bench order.
My lord, kindly, my lord, start comparing.
What can be done? But appeal is admitted.
My lord, there have
My
no
lord,
interim, my
directions
lord,
were, my
there
lord,
have
my
no
appeal
stay
will
order,
become
my lord's
infructuous
order.
in that case.
My lord, kindly, there have no
Can
stay
restore
order.
it. You could not get the stay.
My lord, my appeal will become infructuous, my lord. If today, my lord, kindly visualize the situation.
But you are not afraid for stay of the order, sir.
No, my lord, there is a application for.
First you file the delay, then
My lord,
not file
no,
the
not delay,
certified
my lord.
copy,
Why,
whatever
may
it
I
may
say,
be.
my lord, say why?
Then
What
the
happened, my lord?
certified copy was
My lord, the
accepted.
certified copy was not there.
Correct. Then it was
Leave was
accepted.
granted to file the appeal without the certified copy. However, later on, my lord, it was directed that for, my lord, a time was given for filing of the certified copy, which we could not file, for which the appeal became, my lord, out of the list, or, my lord, dismissed. Thereafter, it was restored again, your lordship.
So-and-so
Kindly, your
appearing for the
lordship.
petitioner, so-and-so appearing for the alleged contemner. Counsel for the alleged contemner is alleged contemner. Police counsel for the alleged contemner has handed over a copy of the order passed by the appellate court dated 24th January 2024 in MAT 81 of 2023, wherein the Honorable Appellate Court has directed to serve the copy of the appeal to the respondent number 1. Full stop. It is full stop. As the alleged contemner has preferred an appeal, though there is no order of stay of the
My lord, my one has not been heard out, your lordship.
stay, but for the interest of justice, the case is adjourned for 4 weeks. Let the matter appear on.
My lord, kindly make it, my lord, 3 weeks.
Lord,
my
kindly
lord,
make it
because my lord, next
6 weeks,
circuit
my
bench,
lord.
my lord, it will be appear.
Yes, it was directed to appear in the next circuit bench as well.
For 3 weeks, let the matter
Yes, my
appear
lord.
on.
I am grateful, my lord.
29th February 20.
My lord. Deeply obliged, your lordship.
Much obliged, my lord.
Yes.
Item number 2.
Not today. Nobody is there.
It is scheduled to be appealed.
20 seconds.
Now on the regular list. Item number 1. You can mention item number 1.
Yes.
Your Lordship, this is regarding an order which was passed on 16th of August 2022 by Your Lordship, in which the case number was mistakenly printed as WPA 16057 instead of 19057. Your Lordship gives a direction for the correction for which the matter is not being taken up under the regular bench, Your Lordship.
The matter is listed as to be mentioned on the prayer made by the counsel for the petitioner. Police. Counsel for the petition submit that in the cause title of the order dated 16th August 2022, this court it is recorded as WPA 16057 of 2012 instead of 19057 of 2012. Consider the submission made by the counsel for the petitioner. Peruse the record. In the order dated 16th August 2022, the WPA number shall be read as 19057 of 2012 instead of WPA 16057 of 2012. This order may be read with order dated 16th August 2012.
Deeply obliged, Your Lordship.
Yes, next.
Item number 2.
Madam, for the writ petitioner.
Yes.
Lord, Mr. Tiwari is appearing in this matter for the respondents. My Lord, I am praying for a week's time on his behalf. Lord, he is held up in a marriage in his family, my Lord. Just a week's time, my lord. He's not here, my lord. There's one last opportunity, my lord. One last
The matter was listed on 31st August. He was not present. 5th October, he was not present. 7th December, he was not present. Let he conduct the marriage, whatever it may be, appear in the marriage, he take all the benefit. Let he take all something.
Lord, one last opportunity.
No. For adjournment, it is very hard from this court. Once in a week, the court is sitting, and I have shown the 3 orders. I don't know what are the further orders. Yes, 10th August also. So appearing for the petitioner. So appearing for the
last chance be given to them.
Respondent. Police counsel for the respondent summoned that the arguing counsel is not in a position to appear before this court. Is not in a position to appear before this court due to some personal difficulties. For the interest of justice, as a matter of last chance, the case is adjourned. It is made clear that on the next date 6, if none appears on behalf of the and on the next date 6, no adjournment shall be given, and the case shall be proceeded accordingly. List the matter on. When you will appear?
Next week, any day next week.
8th of February 20.
Okay.
Grateful, madam.
Item number 3.
File has come. File not. None appears on behalf of either of the parties. None appears on behalf of either of the parties. For the interest of justice, the case is adjourned. Let the matter appear on 22nd February.
On the application, item number 4 to 10.
But I appear for the alleged continuity.
Yes.
And I'm for the petition.
I'm appearing.
নিচু কেন রে? টেবিলগুলো উঁচু আর আমার কি আছে?
The Lordship has heard this contempt matter at length. My Lord, Mr. Shanal, my Lord, senior friend, has made elaborate objection with regard to the compliance which I have filed by stating, by taking out an exception to the affidavit of compliance.
Yes.
My Lord, subject to correction, my Lord, senior friend's contention is that there is no compliance at all. So, my Lord, there are several writ petitions on the same count, and several affidavits of compliance were filed by the concerned block development officer. I represent the alleged contemners, that is the block development officers. And the senior friend is appearing for the other contemners. My Lord,
Number 1.
respondent number 1, contender number 1. With my Lord, with regard to all this contempt application, if I take your Lordship's to your Lordship's order passed in the writ petition, it's an elaborate judgment and order. Dated 7th April 2022.
Yes.
Your Lordship got that. But I'll not trouble your Lordship with the entire elaborate judgment. Your Lordship's ordering portion, that order directing the authorities to take a step, is at internal page number 18 of the judgment.
My lord, I will start from the penultimate paragraph. The contention raised by the respondent that the scheme came to an end on 31st March 2018 and thereafter the service of the petitioner was not extended is contrary to the documents available on record and the certificate issued by the BDO, and thus the stand taken by the respondent is not sustainable. In view of the above, this court is of the view that the petitioners were engaged in the year 2011, except the petitioner number so and so, as the petitioner namely so and so was engaged on so and so. And since then, the petitioners are continuously working as contractual worker, and thus the respondent are directed. Lordship may kindly mark that. We have been directed to grant the benefit of enhancement of financial and other benefits in terms of the memorandum dated 28th May 2013, 6th December 2013, 25th February 2016, and 8th February 2019 to the petitioners within a period of 4 weeks from the date of communication of the order. So, Your Lordship's direction is clear as noonday. Your Lordship directed the respondents to grant the benefit of enhancement of financial and other benefits in terms of the said memorandums within a period of 4 weeks. We are in contempt before Your Lordship, my lord. We filed an affidavit of compliance in this matter. By filing the affidavit of compliance, my lord, we have annexed the order. The Lordship is taking up CPN 1397.
Yes.
My lord, then the order is at page 16, the affidavit of compliance.
Yes.
Sri Subhashish Chakraborty was engaged as block coordinator, my lord. It starts from page 16. I'll not trouble your lordship with this elaborate order passed in compliance of your lordship's order. If your lordship kindly takes up page 17, the next page. Therefore, in compliance with the last paragraph, in compliance with the solemn judgment and order dated so and so, in its letter and spirit, the following order is passed.
এটা কোন কার এফিডেভিট?
Subhashish Chakraborty. My lord, my senior friend is Subhashish Chakraborty. So, page number 17 is 15 no 17.
মিলছে না তো কি রে ভাই?
Yes, content number 4.
উমার সান্যাল কম করেছে, উমার সান্যাল শুভদীপ পালি
এটাও আছে, উর্মি সান্যাল আছে, ওদের আছে।
না,
compliance রিপোর্টটা তো সব জায়গায় আছে।
No, this is the order
1397. Because my senior friend is not finding it. Filed by the alleged contempt of block development officer. সব জায়গায়
পেজ মিলছে না,
সব জায়গায় সুবিধা
দেখ মিলছে না,
পেজ নাম্বার মিলবে না, আমি
দেখছি ছেড়ে আমি, তুই বল। এইটা
না এটা নয়, আমাদের কমপ্লেক্সটা কোথায় গেছে?
এটা
এটা কি? পেয়ে গেছে। হ্যাঁ,
তুই অন্যটার থেকে পড়ছিস?
না একই,
ডিপোনেন্ট তো আলাদা।
মিলিয়ে দিচ্ছি,
ওই মিলছে না, তুই ভালো করে দেখ।
আর একটা রেসপন্ডেন্ট, দিস ইজ contempt number 5 আর একটা হচ্ছে contempt number 4. if possibly it is not there in your file, you just check it out in your bag.
এটা contempt number 4,
contempt number 4 টা আমি পড়ছি। আমি তোমার কাছে যেটা রয়েছে এটা contempt number 5. মানে I'm sorry to, because my learner was not able to find it.
Take your time.
But I've shown him that the page numbers are not telling, because I'm showing him that affidavit of compliance. It is there annexed in that copy also. So if the lordship kindly sees, therefore in my lord, I have page 17.
Yes.
In compliance of the solemn order in this letter speed, the following order is passed in terms of memorandum of 2013 issued by the finance department, read with memorandum dated 6th December 2013 issued by the Punjab Rural Development Department. The monthly consolidated remuneration of Sri so and so, a contractual staff, is fixed to the tune of rupees fixed. Well, this is with regard to the calculation as has been increased, enhanced, as has been enhanced. Then again, my lord, in the next paragraph, in terms of memorandum of 2016, the monthly consolidated remuneration is fixed to the tune of rupees 11,500. From 8,500, it comes to 11,500. Then in the next paragraph, in terms of memorandum dated 8th February 2019, the monthly consolidated remuneration is fixed to the tune of rupees 15,500. It is increased by 400. Has the lordship got that?
Yes.
Then, my lord, a detailed calculation, paragraph number 4, as to entitlement of monthly remuneration in terms of the above orders and the actual payments so far made to Sri so and so till date has been exercised. Now, if your lordship kindly sees page number 19. The next paragraph, that is the last page of the order is hereby granting financial and other benefits to the contractual staff Shri Subhash Chakraborty in terms of the aforesaid. My Lordship may kindly mark that. Granting financial and other benefits. Now, if your Lordship kindly sees your Lordship may kindly come back to your Lordship's order. Internal page number 18.
Yes.
My Lord's order was the respondents are directed, my Lord, page number 18, last paragraph, are directed to grant the benefit of enhancement of financial and other benefits in terms of the said memorandum. And I have mentioned in my reasoned order, granting financial and other benefits, enhancement, I have shown the chart in the earlier paragraphs, to the contractual staff in terms of the aforesaid memorandum of 2013, 2016, and 2019.
Yes.
Against the sanction vacancy post. Now, my Lord, my learned senior friend's contention on the other day was that the alleged contemner has not mentioned in this order of compliance that my job is secure till the age of 60 years in terms of that memorandum. Lord, I am saying that I am giving you all the benefit under that memorandum, whatever benefit, not only 60 years. If you are entitled to post-retirement, whatever benefit, honorarium, you are entitled to that also. If you are entitled to $1,000, you are entitled to that also. But a government servant, when he is given a job, he said that you are hereby appointed in terms of West Bengal service rules so and so. It is not mentioned in that appointment letter that your service is still 60 years. Your remuneration is fixed at rupees this. It will be increased after 5 years to rupees this. After 10 years to rupees this. You will be entitled to HRA rupees this. Everything, whatever is there under the memorandum, you are entitled to that memorandum. I am duty bound to do so. This is my promise made to you in terms of your Lordship's order. This is my promise made to you.
Correct.
Well, this is extending, deepest of respect, this is extending the scope of the contempt application.
Okay. And next.
Next is with regard to the calculation of this particular person, Subhash Chakraborty.
Yes.
Now, why there has been a deduction? Well, as I gathered, was subject to correction, my learned senior friend, as I gathered from his contention that this particular person was working in 2 different jobs at the same time, subject to correction, my learned senior friend. So, my learned senior friend says that since I was working under the Panchayat Shomiti, I was paid remuneration for that. You don't have to look into that. Since you are duty bound to engage me as a contractual worker in terms of this, you have to pay me this. Whatever I have drawn from that, it is none of your business. Unheard of. A government employee
cannot draw the
drawing amount from the government exchequer, the Gram Panchayat or the Shomiti also gives the salary from the government exchequer. My lord, a person cannot be employed in 2 different employments at the same time.
Correct.
Unheard of. Well, this is also, my lord, with deepest of respect, extending the scope of the contempt application. I cannot deduct if I have drawn the amount from that particular employment, and when I am entitling you in compliance of a lordship's order with regard to this memorandum, when your salary is increased by virtue of each memorandum from 8,000 to 11,000 to 15,000 to 19,000, whatever it is, when I calculate the entire amount, then whatever extra you have drawn, that has to be deducted. That has to be done in any employment. My learned friend don't know I have been doing a different job altogether, a different job.
That's all.
Well, it's coming. What is that? Grateful to your lordship, my lord, because this is simple as my respectful submission, my lord. The orders which has been passed in compliance of your lordship's order, though belatedly, my lord, with for which, my lord, I tender my unconditional apology, but the order of your lordship has been complied in letter and spirit, my lord.
Okay. Yes, Mr. Sanyal, any reply?
Now, your lordships, kindly take up the contempt application তুই বলতে পারছিস না, একজনে কি দেয়? What is that? রিট পিটিশনটা বার করে শুভাশিসে। My lord, I placed it your lordships. Your lordships order under contained, my lord, in the contempt application at page 42. To grant the benefit of enhancement of financial and other benefits. Now, my learned friend says, your lordships kindly take up the compliance report. My lord, that's, my lord, I have been served with affidavit by Shubhodip Pali, my lord, Block Development Officer, Rajnagar Development Block, consumer number 5 in Shubhashish Chakraborty.
Subodhit Palit.
Pali.
That is in respect of Subhasis Chakraborty.
Shubhashish Chakraborty.
No, that is no, that is in the WP.
পেজ নাম্বারটা মিলবে না বলে
হ্যাঁ, তো অন্যটা দেখি।
শুভদীপ পাল
পেয়েছিস?
হ্যাঁ। That is also in CPN 1397.
Yes, it is.
Now your losses will kindly come to page 22.
22
of the affidavit. এটা পরে এখানে বলেছিলাম, দেখি জিজ্ঞাসা করে করতে পারিস। The last paragraph, the order is hereby granting financial and other benefits to the contractual staff of Subhasis Chakraborty in terms of that. As your lordships passed an order, that exact the verbatim has been quoted. Page 22, last
23.
In my affidavit 22, any event, your lordships. Just have it over the 23 will.
In 1397, in one Urmi Sanyal. Which affidavit? Which?
I am placing, my lord, Shubhodip Pali.
Same thing, my lord. It is page number 19 in Urmi Sanyal's affidavit. And it
okay, whatever. Okay.
It will be page 22 in Shubhodip Pali's affidavit.
Okay, whatever.
Now, your lordships kindly consider the first memorandum, 28 May 2013.
Yes.
28
Actually, that might be 20 May.
20 May.
Yes.
20 May 2013. Your lordships will be getting it at page, if I'm not wrong, my lord. 28 May 2013. Your lordships will be getting at page, just a minute,
Page 78 of the writ petition.
76 of the writ petition.
76. 20 May, yes.
Now, your lordships, kindly see the first paragraph. In terms of this department, dated, my lord, memo dated 9008F, dated 16th September 2011. Your lordships will be getting it at page 73 of the writ petition. Well, the very first Roman paragraph. The casual and daily rated contractual workers.
Okay, which one? Where?
Page 73 of the writ petition.
73. Yes. Daily rated contractual workers who have rendered 10-year service
Continuously with at least 24 days attendance each year may remain engaged in the same status and capacity till they are attaining age of 60. Malad, this is the parent notification. Malad, page 76 is the continuation of that.
Yes.
I'm referring to 73 to show your lordships. Page 76 is a continuation of that. Now, kindly see page 76. In terms of the department memo, it was decided to allow appropriate emulation and other certain terminal benefits. Well, your lordships will find the next, the undersigned budget, then enhancement. Your lordships will find, and then your lordships, last line of the same memorandum, all other terms and conditions will be same as in the finance department memo. That means, Lord, it's reiterate that they will continue till age 60. Then your losses kindly, the next notification, 6 Malak 12/2013, that your losses will be finding at page 78. Malak paragraph 3. In each case, the provisions of the memorandum dated memorandum number 9008, the parent one, of 16 September 2011 of the final hassle has to be strictly followed. I'm showing it because the consequences follows from 11 with for other benefits.
That's the parent memo is 16 September.
My lord, then your losses will find at page 80 capital A, type copy.
Yes.
All contractual and casual and daily rated workers shall continue to be in engagement up to the age of 60 years. Engagement of contractual, casual, and daily rated workers shall not be terminated except as prescribed in the aforesaid memo. There is a little addition, your lordships. Not only continuation, some security of service is given. Then your lordships will find 8 February 2019, that's at page
94.
19.
94.
94. 94, your lordship. Roman 2. With effect from 1st February 2019, such workers on attaining the age of 60 years will be entitled to one terminal benefit of rupees 3 lakhs in place of existing of 2 lakhs. My learned friends' contention, the benefit, apart from enhancement of finance benefit, they have given a paragraph wise how they have calculated and given. I'm going to this subsequently to that. The other benefits word includes all. That's, if I'm not wrong, this is the submission. In their order of compliance, they have rated the other benefits, and therefore it includes my continuation of service to the age of 60, terminal benefit, whatever happens. Now, Malab, kindly see what they order they usually pass in these sort of matters. I should take your losses to that. But if your losses kindly take up my affidavit of exception to this affidavit. এটাই তো কোন প্যারাগ্রাফ তো মানে affirmed by Subhashish Chakraborty.
Yes.
Now, your losses will, may I place the paragraph, then I will take your losses to the issued memorandum. Now, your losses, and who is the issuing authority? Lord, kindly take up page 8 of my paragraph Roman I. It is noteworthy that in terms of the provisions of clause Roman 14 of memo dated such and such, which is the parent memorandum, in continuation of which the aforesaid memo have been issued, the final approval towards grant of the benefit as ensigned in the aforesaid is to be given by the additional chief secretary, principal secretary, secretary as the case may be of the concerned department. Why I am saying it, your lordships, I will take to their affidavit. They repeatedly wrote to the highest official, Mr. Deb's client, please do it so that we can comply with it. They didn't receive anything. Now, ultimately, under the threat of contempt, they have issued that giving the financial benefits, including the words, charming words, other benefits. It will impact me in future because unless you do this, as you have done in all other cases, I will be in a soak in future. Kindly look at Lordship J. However, in the aforesaid order dated such a 3rd August 2023, there is no reference to any such approval having been granted by the additional chief secretary and principal secretary, secretary of the Panchayat and Rural Development Department, which is the concerned department in the instant case, nor has any affidavit of compliance been filed till date by the contender number 1 herein and the Secretary Department Panchayat of Rural Development of West Bengal. Such approval orders have been passed in respect of the private respondents number 14, 15, 16 to the writ petition. Shri Devoprasad Saha, Shri Sumanto Chakraborty, Shri Mrityunjoy Das. But I gave certain examples that I am not being giving these benefits. Those persons who are similarly situated have been given those benefits in the writ petition itself. I made them party also. By the Joint Secretary, the Department of Panchayat and Rural Development, Government of West Bengal. Now, photocopies of the memo and the approval orders annexed. I will take your lots. Kindly allow me to proceed. Paragraph K. Thus, issuance of a formal approval order by the additional chief secretary, principal secretary, secretary of the Department of Panchayat, Rural Development, Government of West Bengal, is a sine qua non for grant of benefits as enumerated in this such and such government memoranda. Simple issuance of the aforesaid order, that's the compliance order, by the block developer, subordinate officer, by the contender number 5 without formal approval of the contender number is meaningless. Because tomorrow, suppose your losses dispose of the contempt application and day after tomorrow they dismiss me, what will happen to my service? Security of my service? Now, the aforesaid memoranda do not only provide for regular enhancement of remuneration, but also provides various other benefits such as remaining engaged till the attainment of age of 60 years and terminal benefits on attaining the age of 60 years, medical benefits, leave benefits. So, unless you give approval to my appointment or engagement, I will not derive those benefits. That's my contention. Only mentioning catching words, other benefits is not the compliance. Your lordship mentioned the memoranda because the memoranda you have to comply with means the spirit, the object and letter have to be complied with by issuing appropriate order, not by giving enhancement till the date of compliance. Therefore, your lordship, such other benefits cannot be enjoyed by the petitioner unless an approval order is passed by the contender number 1. The contender number 5 himself has admitted in paragraph 5 of the affidavit under reply that additional chief secretary, principal secretary, secretary of the concerned department is the appropriate authority for according administrative approval for grant of aforesaid benefits. I will take your losses to paragraph 5 of their affidavit. Thus, the aforesaid judgment and order dated 7th April has not yet been complied with by the contemners, and they more particularly have been continuing to violate the said judgment and order of the Honorable Court. But this is at the formal malad. Then other point I am coming. But there your losses kindly come at paragraph 5 of the affidavit of Subodip Pali. There is no affidavit, if I am not wrong, on the part of the contender number 5 content number 1, 3, content number 1. No compliance of affidavit. Now you'll also kindly see paragraph 5. It is respectfully submitted that has you also got that one? Page 3. It is respectfully submitted that pursuant to the aforesaid solemn judgment and was made by the district magistrate and the order correspondences. Correspondence. I am not referring the dates. Was made by the district magistrate Birbhum with the state authority seeking administrative approval for grant of enhancement of financial benefits and other benefits to the petitioners in terms of the aforesaid memoranda, since the memoranda being 9008, well, the parent memoranda issued by the Finance Department, Government of West Bengal, which is the parent memorandum, and such and such to the such and such, lays down that the additional chief secretary is the appropriate authority for according administrative approval for grant of such benefits. Now I take your lordships to the order of compliance. Can you have a look at this? Well, I stand corrected if the any order of approval from the appropriate authority mentioned in this order of compliance. I do not find it, your lordships. This is just a camouflage, my lord. Give the financial benefit. Probably I will come up. Yes, compliance. Your contempt application disposed of. Tomorrow they will start playing with me. Kindly have a look at, my lord. Paragraph page 19. Where is the approval of the competent authority? Because its consequent service should benefit. My lord, kindly have a look at that. Now, first paragraph, Subhash in the block coordinator. My lord, kindly I request your lordships to take this word block coordinator, because in dealing with the second submission of my learned friend, this will be very relevant. In the block coordinator in the block, contractual basis. Now, Chocko filed a writ petition, your lordships. That's the, my lord, reiteration, appeal. The next page, second paragraph, appeal. Then third page, contempt application, and thereafter the compliance. My lord, where is the reference of the approval? But I'm, of course, putting a question to myself. So unless there is an approval, just because finance, the enhancement up to the date of compliance you have given to the month will not entail those benefits in my favor.
Yes.
They are all saying that he is the ultimate authority of approving. Now your lordships will find, kindly see page 37.
37
of the my reply, exception. How they have issued the order in respect of others for enjoying the benefits of this memoranda. All the memoranda. Kindly, this is 21st November 2019. He was a party to the writ petition. In pursuance of the Finance Department memo dated. Kindly see the first memo. In my compliance order, this memo has not been referred to. Read with memoranda is such and such. This is to say, the Debo Prasad Sahay casually engaged clerk cum typist Bolpur Sandhya block was engaged against the various sanction post such and such. Since then, they passed, Debo Prasad Sahay has remained engaged to the said established in the same capacity of continuously without any break with 2 formats. These are the conditions. And has now rendered more than 10 continuous such satisfactory day till date. Block development officers has issued the necessary certificate in terms of para 1. But kindly, I take your lordship page 73, para 1. What is para 1 of the writ petition? Yes. Kindly come, Lord. Page 73. Para 1 means I will continue till the age of 60. Have you referred it in your order, compliance? Because you don't have the approval. That's why you have not been able to record it. Well, this is sheer violation of the further contemptuous act on their part. They cannot play with the court. Kindly see the consequential benefits. Suppose your lordships, they engage me today. They come before with area salary, your lordship directed approval with area salary. They gave me the approval area salary without approval. After retirement, would I get the benefit of pension? Unless my post is sanctioned, approval is given. This is the consequence of service jurisprudence. Okay. This is my first submission. They have not complied with the order in the term, spirit, and letter of your lordships. The second submission, your lordships, that I took your lordships to the very order, your lordships, affidavit of compliance. Well, kindly will look at the very compliance order passed by them. Well, I've given as an example block coordinator. Is your lordship getting it? Block coordinator. So I was engaged as a block coordinator in the block. Well, block is one office of the government. Panchayat office is not the government office.
Yes.
Yes. Now your losses kindly will look at take my exception. I just take your losses one document to show this is exception. Just a minute. Just a minute, I have. Oh, I think. Just a minute, I have. I will show my lord one resolution. Just for copy name. Just a minute, I'm sorry, my lord, I have. My lord, page 15. My lord, after my usual hours of work, my service is being utilized by the panchayat. That's a different office. And for that utilization of my service, they used to pay 3,000 rupees. Malad, kindly will look at this resolution of the panchayat. Malad, Sthai Shomiti Sabha. Malad, this is Bengali language vernacular. অর্থ সংস্থা উন্নয়ন ও পরিকল্পনা স্থায়ী সমিতির সভা. Malad, the last paragraph, I read it to your lordships. Malad, as a Bengali vernacular.
Yes, yes.
Malad, Rajnagar Panchayat Samiti. Malad, Panchayat Samiti is not a government office. নবনির্মিত চারটি স্টল
Samiti is not a government office.
No, Panchayat Samiti is not a government office, Malad. No, Malad.
3 tier. It is not 2 tier.
It's a 3 tier Panchayat.
No. Panchayat, Samiti, and Jila.
Yes, 3 tier. Malad, those are not the government servants. Malad, I tell you, public servant they may be, but they may not be government servant.
Okay.
Malad, your lordships kindly consider the next page. সাক্ষরতা মিশন কর্তৃক নিযুক্ত কন্ট্রাকচুয়াল কর্মী শ্রী শুভাশিস চক্রবর্তীকে পঞ্চায়েত সমিতির করসপন্ডেন্স দেখভালের জন্য ৩,০০০ টাকা পঞ্চায়েত সমিতির ওন ফান্ড থেকে সেপ্টেম্বর 14 দেওয়ার সিদ্ধান্ত দেওয়া হলো। So Malad, I do this after the evening hours. This temporary job I perform. How could you adjust this money with the benefits under the government orders for block coordinator? Kindly visualize your losses. This is my point.
No,
What
but where is this after the working hours?
Malad, I have said on.
You have said.
I'm just showing to you.
Whether it's a resolution.
I'm showing.
A resolution that he will.
I'm doing.
In addition to his own work. Even though Mr. Sanyal, even though Mr. Sanyal, if you are telling that he is a government servant as per the memorandum, he has been brought under as a government servant. Can he claim the other benefit from the other? If it is not other dependent as per my view, but subject to correction, can he claim the other benefit? Only you can say he was getting the 3,000 rupees and now they have given that amount.
No, I tell you.
The difference has been
I tell you, Lordship. My claim in the writ petition that I have worked as a block coordinator.
Correct.
I have, and according to the government memorandum, I am entitled to this enhancement and other benefits.
Correct.
There is no dispute that I have not rendered the block government. I have rendered. So your losses directed the announcement. They have given the announcement. While giving announcement, the back announcement area, they are adjusting what I'm doing in other offices. How could they, Malad? That's the Malad. For the job of the other offices, I am not asking the announcement.
So where is the document that you are also worked as a coordinator in the panchayat during this period?
Well, coordinator, I'm not panchayat. I'm in the block.
Yes, you are.
I'm in the block, another office.
What is the post?
Block coordinator in the block.
Coordinator in the block.
Block. And this is the Panchayat
The
Samiti.
Panchayat Samiti.
Exactly.
Correct. Where is the document that you had worked in the as a block coordinator also during this period?
Entire period I have.
Because when the writ petition was heard, you were working and you have been posted there, and you have stated that the benefit of the memorandum is to be given. Because other persons have also working, the certificate was given by the department in connection with the some of the persons, leaving aside your name. So when this court has considered and this court find that yes, you are also worked for the same period, but your name was not forwarded, then this court has directed. So with regard to this 3,000 in the panchayat and the block, where is the document?
My first point, your losses,
And whether that
this is not their case. I have not worked as block coordinator. This is not their contention in either of
and whether that can be decided in the contempt.
But I'm not. I'm not. Therefore, there is no lease before your lawsuits.
Correct.
All that I'm pointing out with the resolution that somebody else paid 3,000 rupees. How could you adjust it with my benefit?
You challenge that
No, therefore, this is not the compliance. This cannot be the compliance of your lordship.
With regard to the approval, to some extent, let the respondent number 1 is here. I will ask the question from the respondent number 1.
No, this is the point.
With regard to the approval, that is one of the, with regard to this, you are at liberty to take up, because in the contempt application, this court cannot.
No, I am not your lordship. I tell you, lordship. Certainly, I get maybe repetition. I am before your lordship for non-compliance. Your lordship is directed that these are the financial benefits.
That's I'm telling. That I will take care of.
But your losses, when giving the financial benefits pursuant to your lordship's order, can they deduct an amount paid by others?
So that's
I'm saying this is the contempt.
Okay.
They cannot do that.
Okay.
They could have, after paying me, complying my order, they can call me by giving a notice. Look, this is it done. I have to deduct it some. Then I can. But in the name of the compliance, you cannot deduct my amount.
No, Mr. Sanyal, what happens in the government service? So I don't know, not so high knowledge in the service matters. With regard to this government servant, sometimes what's happened, the department was the department, so he is working in this son department is getting. Unfortunately, the other department is also taking care and issuing the receipt and paying the amount. Sometimes it's happened. So double payment, and the department is having authority to recover that amount. Here also, you are telling that you are the coordinator. Correct. Coordinator, you are working something, but you have not been regularized. You approach the court has passed an order. But subsequently, at the time of regularization of compliance of the order, whatever it may be, the authorities found that you have also received 3,000 rupees per month.
For whom, my lord? From not them. Not from them, my lord.
Government.
I may be wrong. I may be wrong.
That's why I am also telling it is subject to correction. Government means administration means either the panchayat or it is the West Bengal.
May I give a crude example to your lordships?
It is not that it is an autonomous body.
Crude example of your lordships. I am an employee of this court contractually. I have to work. I do my work. Now, I do additional work before another authority. While paying the benefit of enhancement of this court's service, can the court adjust the benefit I have derived from other authority? I am consciously doing it. When I am coordinator of a block, it's a government office. Panchayat Samiti employees are not the government officers.
It is not.
I tell you, suppose you're municipal employees of the municipal.
No, it is not coming under the directorate of panchayat.
I did not want to join issue because my learned senior friend was making submission. If he can show that this amount of panchayat samiti is coming from someone's uncle's pocket, all this money is coming from government exchequer. No, just 2 minutes. Just 2 minutes. I'm sorry to interject. I'll tell you, lordship. The case before your lordship, when the writ petition was initially moved, Shakhar Bharat Abhijan is a centrally sponsored scheme. Now, this Shakhar Bharat Abhijan in 2015 was ended.
Correct.
But due to you don't have any work to do. So they came up before your lordship. No, they have guaranteed us in terms of this memorandum that we will be there till the age we attain the age of 60 years. So there was a litigation before your lordship. Many people who were not performing job at that point of time. They got themselves engaged with many other jobs. And this petitioner was also, since he became jobless, he was asked to go and work for the Panchayat Samiti at that point of time. And he drew salary from the Panchayat Samiti from the government exchequer. And I challenge myself, my learned senior friend, but I'm using this harsh expression, this crude expression, the word crude he has used, that it is a blatant lie that he was working in the evening there and in the morning there. It is a blatant lie.
But I tell you, loss.
Please. Untrue statement, because I took my officer to task that how can I deduct the amount? I took my officer to task. He told me that this stopgap period, when there was no work under the block coordinator, we asked him to work here in the Panchayat Samiti. We utilized their work. And that is why your lordship said when you have utilized them, you engage them till the age of 60 years.
Okay. I tell you, loss. Mayor fund coming from the government exchequer does not make an employee government employee.
No, not
Kindly
God.
consider that. My learned friend, basic contention in law, fund comes from the government. Merely fund, consciously say that. Suppose, my lord, I am a registered society. I am being paid from the government fund because government grant is receiving by the society. But not another aspect. You are in the concept of law. Just because my salary is being from the government fund, I do not become a government employee. I am still an employee of the society, but it may be an Article 12 of the Constitution of India. Here, your lordship, being and working as a panchayat, I do not become an employee of the block. That's my contention. Okay. Block is absolutely a government office. Panchayat Samiti is not a government office. Therefore, you cannot adjust.
I defer there. I defer there because Panchayat Samiti and not Jila Parishad, Panchayat and Samiti will coming under the Directorate of Panchayat.
Directorate of Panchayat is not the employee. I tell you, lordship, municipal officers will come under the Department of Municipal Affairs. Correct. That doesn't mean corporation officers will become the government officers.
Corporation is different.
Our service rules are different. Our service rules are Panchayat Samiti. Very concept is different. Very concept is different. So how could they adjust it, your lordship? Okay. This is one thing, your lordship. Thank you. The other two things, only that's I miss. In respect of two, they have considered my service for a lesser period. The two other sir, this service, the adjustment only relates to the Subhasis, not other. The first point relates to all of them. The approval point to all of them. The adjustment point relates to only Subhasis. And the 2 points your lordship. সজল কোথায় বলেছি দেখাতে হবে তো আমাকে in respect of সজল and সজয় চিন্মল and পার্থ they have in the order mentioned a lesser period of service. That may futures because of my ultimate counting of service from 2011. Show any one of them. That's the point. That's not. They should correct it, your losses, because otherwise, in the long run, I will be in the difficulty.
But if there is some, I don't want to enter into this argument with regard to lesser. If there is some mistake in calculating the period of service, well, I'll certainly ask my officers to correct that. Because I am only with regard to their entitlement, my lord, in compliance of a lordship's order.
But only with regard to
approval.
Approval.
My lord, a senior friend, my lord, is appearing for the district magistrate.
Yes. What about the approval?
District magistrate.
The district principal secretary.
Principal secretary or assistant secretary, whatever, additional secretary.
Additional chief secretary. Well, either take instruction from my specific instruction, my lord. It is a department of library and mass education. This is not under the part of.
No, but the earlier orders which have been on the basis of which they have filed the writ application, that has been approved by the additional chief secretary.
And paragraph 5 of the contempt number 5 affidavit.
No, my lord, that paragraph I just want to make certain things clear with regard to that paragraph 5, which was pointed out that we sought for an approval from the additional chief secretary. The directions came that we have to prefer an appeal against your lordship's order. We preferred an against the the authorities preferred an appeal against your lordship's order. The appeal is still pending, and there was no order of stay. So when there is no order of stay, when specifically the order of stay was refused, then I'm duty bound to comply with your lordship's order. We have done so. Now, only contention, my lord, is that since in other cases there has been approval by the highest authority, in future everything is in under apprehension that I am apprehending.
What is the stage of the what is the
No,
stage
no,
of the just what is the stage of the appeal?
My lord, I'm told by
Or
my
otherwise-
by
or
the
otherwise-
junior of my learned senior friend that they have mentioned the matter
Or
either
otherwise,
yesterday or day before
what I
yesterday.
will suggest, let it be kept pending till because you have got that. If the appeal will be dismissed, then all the things will be decided.
Why
And
your losses utter the word dismissal?
Huh?
Why should your losses?
There. There.
Let them say that.
But I am not appearing in that. I am not in that appeal, my lord. My duty is confined to the
Support
court.
your lordship's order everywhere. Because I've got it.
But,
Why should I?
my lord, even stricto sensu, my lord, if the appeal is dismissed by an elaborate judgment, then, my lord, in view of the subject to KRISHNA land survey, in view of the doctrine of merger, then the quantum will lie before the honorable division bench, not before your lordship. Then,
That's correct.
my lord, I will come back, my lord, for your lordship, because, my lord, my instructions, the BDOs are paying the amount not from their pocket. They are taking the money from the
That's
authority.
correct. That I will
So
that.
approval is always there.
I have
Approval
taken-
is always there.
Only with regard to this. Only with regard to the approval. Because what will happen tomorrow? This officers will be transferred here and there. They will be at the verge of retirement. Then the file will come. Then they will say there is no approval.
Pension times becomes difficult.
It happens.
Every time happens, my lord.
Because personally, I have conducted one case. One person was appointed as a librarian. He was continued. They have been given the senior librarian and all this. But subsequently, it is found that this appointment of the librarian was not approved.
Post was not sanctioned.
My lord,
Then pension
my
will
lord,
not
in
give.
fact, my lord, it happens. We are seeing it regularly now in municipal matters.
That is the
That
everyday.
municipal employees, my lord, in municipality gave them the job, but that approval has to come from the urban development department, and that approval is not taken. And this person has worked for 20, 30 years, and then we say that
Municipal authority everywhere in our Andaman also, they are taking there's a daily rate and mazdoor. And continuously after the 7 or 10, 5 years, May Day, once the May Day come, 100% will be regularized. Without the
approval of the
That is the May Day gift.
May Day gift.
Without sanction approval, it will be difficult.
Mr. Debra will take instructions.
So you take instruction. I am fixing within week, next week. So I have concluded. Let they come with the approval. Otherwise, if you will give the undertaking, I will record that. And regarding your money, I will.
And so the other contention, your losses keep.
I am keeping that.
Other contention
ওই যে টাকাটা যদি পাবো না পঞ্চায়েতেরটা ছাবো কেন
পঞ্চায়েতটা
এখানে যত লিপ দিলে আবার যাবো দেখিয়ে দেবো আমি তোকে পঞ্চায়েত আর ব্লক
দাদা আমি ওটা দেখি ওটা আমি নেবো জিপির কাছ থেকে ওটা নেবার জন্য ফসলে লড়ার জন্য দেখি আর ওই লোকটার কি করে সন্ধ্যাবেলা জব করছিল আমি ওটাও দেখে
আমি দেখে শোনো
আমি লাস্ট পর্যন্ত লড়বো
পঞ্চায়েত সমিতির এমপ্লয়ি ইজ নট এ
Given by the
পঞ্চায়েত সমিতিকে টাকা
concerned authorities.
কনসেপ্টের ব্যাপারটা হচ্ছে যে আমি তোমাকে বলে দিলাম 2015-তে যখন স্কিমটা টার্মিনেট হয়ে গেছে
Issuance of
কোঅর্ডিনেটর
আর একটা আসবে
the order
ওটা
dated 3rd August 2023,
আমি বলছি
wherein
আমি
stated that
পাঠিয়েছিলাম
it is stated by the alleged contemners that the contemners have complied with the order. Have complied with the order. Let the instruction may be taken within a week. This is the matter on 9th of February 2020. 9th, no, 9th is Friday, 8th. 8th February. 8th February.
8th February.
Next week.
হলো ডে
আবার ওসব বলা
নেক্সট উইক থাকবো
Lordship shall record, my lord, whether the approval,
That's how you record it. Only for the purpose of taking instruction, whether at the time of issuance of the order, approval was taken.
this order will be uploaded in the server so that my learners will get
Not today, tomorrow, because my side is different, so it will
and
take.
difficulty your losses. Suppose, my lord, your losses record that and dispose it off. At the time of getting final benefit, I have to carry your lordship's order.
Correct, correct.
You have to of course, otherwise I will not get it.
No,
Because there
I
is no
understand your
approval order.
difficulty. That's why
I have to, wherever I will go, I have to carry your lordship's
Mr.
order.
Sharnal has experience because he used to appear for the primary school council in many matters.
I have appeared so
and the
many of
primary
those.
and these teachers used to get the orders from the High Court, and when asking for the benefits, they have to run from pillar to post, showing that this is the order of the High Court.
What happened in 1980, in Andaman, 1985, 84, 80s, there was no rush in the employment. So who have completed the B.Ed, completed the graduation, go to that school, go to that school. It has been given. After the 90s, when the starts recruitment, then there is no approval of the 84. There is no approval of at the time of promotion. Where is your original appointment?
Required. Pension is stopped. Pension will not be disbursed.
In that point of time, my lord, there was no such selection exam test and all these things, my lord. Open
Then one matter
advertisement.
went up to the Supreme Court. Then Supreme Court had decided
That there has to be a regular way of appointment, and that you have to selection and appointment and everything.
Then it was.
Even, my lord, I am shocked. One of my father's friend, he's a doctor. He told me that in our times there was no joint entrance examination. Passed HS, good marks, got admission in the
go and join that hospital. Okay, thank you.
Good.